Okay. Welcome to the meeting of the California Paraprofessional Program Working Group. I'd like to begin by taking roll. Bashan,
Present.
Reynolson,
Present.
Falmouth,
Here.
Fleischman,
Here.
Hamilton.
Present.
Judge Harper indicated that he will be late. Hartston,
Here.
Kirkmeyer,
Here.
McRae,
Here.
Olvera,
Here.
Justice Petru,
Here.
Robinson. Judge Rubin indicated he was not going to be available today. Shining, Sarouche, Spyro,
Here.
Doris Ambris. Judge Wiley indicated that she's going to be late. And Judge Yu,
Here. Thank you.
thank you. So we have a quorum. We can begin.
Do you have any remarks you wanted to make, Justice Petru?
No, I don't think so, unless there's something you think that we need to address right now. I think the general remarks I have, I'll hold till we have a full meeting or a more complete complement of the working group. Do any of the attendees wish to make any comments? If so, could you please, I see one hand. Anyone else? I see 2, 3. Okay, there are more coming up. We're going to have to hold on the comments then, because the person who's leading our first conversation is under some extreme time pressure. So Linda, if you could, or Leah, however you want to do this, if you could go ahead and start the first part of this, and then when we pause after discipline, we'll take public comment.
Okay, Carolyn, I see you have your hand up. Did you just want us to know you're here?
No, I want to join.
You want to join? You're in the meeting.
You're in the meeting, Karen.
Oh, okay. Sorry.
Okay. All right, Kim, you want to kick off our discussion?
Absolutely. Well, great and good morning, everyone. Thank you for letting me present the discipline subcommittee presentation. As I go through, any of my other participants in the subcommittee, if you want to join in or add something, please feel free to do so. I'm just really going to walk you through the memo. I know we've really gone over the process that we've kind of thought would be the best for this group of licensees when they get licensed individuals. But I wanted to just go over it briefly just so we could kind of talk about it. And in our memo, we've kind of done, rather than a flow chart, the flow chart is here on what Linda's projecting. But the table actually kind of gives it a little bit of an easier dynamic. So I thought we would run through that. So if you're looking at the bottom level of the flow chart, that's the complaint intake and investigation. Again, we've gone over this in the past, but this really is going to be handled by the Office of Chief Trial Counsel, or OCTC. That's kind of what we've thought. So it'll come in, it'll go through that review process and be looked at. We do think that, again, that's the appropriate level of where we would keep it. Again, just going back to, we've kind of done this part with the way the state bar does it, and part going outside of the state bar process, and we can kind of show you that as we go through. Then the next step would be really getting into that investigation piece. And again, that investigation part, it would be done again through OCTC. Looking at it, going through, investigating the allegations in that complaint as it's going through. The one thing that we have added, which is a different than the way the state bar does, is we've actually added a citation and fine program to where if the violation is a minor violation, we would issue a citation for that individual. The other thing that would be part of it, depending on what that citation was potentially an order of abatement and then a fine attached to it. So those are things that we have added into this process as well. Then as it goes on, if it does, it's not closed out at that point and it's going to go forward, then it would be going forward. And what we've decided is the initial hearing that's going to be done is going to be done by this 3-person hearing panel. So that's a staff adjudicator, a paraprofessional, and a public member. So those individuals would be trained, they would understand the process, and they would be able to sit on that hearing panel. If it actually goes through, and obviously too, back to the citation and fine from the chart here, if it is a disputed fine or fee determination, that would go to that panel as well. Then if it goes to a settlement conference, it would take place only if one of the sides mutually consent to having that settlement conference. And that would actually be held by a staff adjudicator to manage the settlement conference. And then if that settlement was reached, depending on what the settlement outcome is, that would go through potentially, right now we have it going through the licensing board approval required. Again, it depends on how the board is set up or what entity is leading the paraprofessional program. But it would go through that individual. Where we really need the input from the working group is to the level of appeal. So when we get to appeal, we have a question whether it should go to another 3-person hearing panel. Obviously, it couldn't be the same one. Have to be a different staff adjudicator, different paraprofessional and public member, or if it should go to this paraprofessional licensing board. That's one of the issues that we have, and I think we're kind of waiting to see what that licensing board would look like and how it's going to be set up before we would really, know for sure how we want to do that. And then obviously the appeal from their level would then go to the Supreme Court of California. If the decisions were appealed by different parties, again, it would go up and it would be appealed to the Supreme Court. And if the action was a license suspension or revocation, that would go to the Supreme Court for that final review and approval by them due to the type of outcome it is. So that's kind of what we put together for the discipline system itself. Happy to open it up to any of our subcommittee members if you have anything that you want to add there or any questions maybe before we go on to the next item of alternative discipline type.
I see Steve Fleischman's hand up.
Yes, would review by the Supreme Court be optional as it is for attorneys right now?
I'm not sure what you mean optional. You mean the ability to appeal a decision?
Yes, but as I understand it, the Supreme Court has discretion whether to take the case or not. And in fact, they typically take very few. Greg, if I'm wrong, tell me.
I think that's correct, but also I think obviously we're not going to be able to impact their discretion, their ability to have discretion. They're going to have discretion whether we want them to or not.
That's correct. So yeah, I mean, for lawyers, either side, OCTC can petition for review if they're dissatisfied with a review department decision, and the respondent lawyer can as well. And review is discretionary.
Thank you.
Okay, so moving on then, if there's nothing else there on that, it doesn't look like I don't see any other hands. Okay, so then getting on to some of the other things that we looked at as a subcommittee, and that was some of these other types of outcomes.
I'm sorry, Kim, Julia does have her hand up.
Sorry.
It's hard to see. Yeah, go ahead, Julia.
Hi, Kim. I was just wondering if you had discussed in your group what advantages you think it would be to appeal to another third-person hearing panel versus appealing to the paraprofessional licensing board.
So the kind of the difference, I think we were thinking some of it is cost. I think we were looking at, right, and I'm looking to our subcommittee group as well. I think we thought the biggest thing we want for appeal, quite frankly, is that there are individuals from that profession that are involved in that decision. So it kind of depends on how that paraprofessional licensing board is set up. It's kind of one of the things why we're kind of going back and forth, whether it should be the 3-person hearing panel or whether it should be the paraprofessional licensing board. So depending on the setup of that board and the individuals involved, I think that was kind of one of our driving factors. And then we kind of thought, well, it's gone to one hearing panel, now it's going to go to another, and there could be potentially duplication in that, as to where it was a larger group that would oversee it if it was the licensing paraprofessional board. And please correct me, anyone on the subcommittee, if they have any other thoughts on that.
Thank you for that. Yeah, because it did seem a little redundant in the sense that the makeup is exactly the same. There'd only be one paraprofessional. So thank you for explaining that.
Okay. All right. So moving on, we looked at some of the alternative discipline or different types of discipline that happens at the state bar level. And some of the things that we looked at on this chart here, you can see were the warning letters. So that one is one basically where OCTC, and where there is no violation, but they determine that some type of action or notification, basically a warning, should be sent to that individual and brought to their attention. We thought that that was something that's good. Just from my perspective is get DCA. We do that a lot with our licensees as well. So we do think that that would be important. It's not discipline. It's not public. It's just something that we thought would be important. So that is one thing we would like to have in our, basically our process that would be available to those processing those complaints. So that one we thought would be great. The next one is an agreement in lieu of discipline. So this is actually what happens there is that this outside source is actually authorized in statute for attorneys. These agreements really are for a lower level of discipline. And we have an example in our memo, I think, but for those types of entities, they enter into this agreement in lieu of discipline. They are again used for that lower level, but they are not considered disciplinary in nature. And the thing is, they're not public. So the subcommittee, we actually thought that it was a benefit, and we actually heard from individuals that spoke to us on the side for the attorneys that do think it is helpful to do. But at the end of the day, in light of everything, we actually did not recommend it because we really think that things that happen that are to the level of disciplinary action should have disciplinary action. We should proceed through the process and have that happen. So that was one thing where we actually veered off from what the attorneys are allowed to do. And you'll see that kind of in a lot of things as we look at what we want to include and exclude. The things that we're excluding really are things where if there's discipline, we believe that it should be taken and we believe that it should be public. And that's kind of why we excluded a lot of the items that we did. The next issue is the mandatory fee arbitration. And so for this particular type of entity, this is really kind of a program that's already allowed. It really provides the ability for individuals to kind of dispute any fee dispute. So it's basically a arbitration between the two parties, and it would be between the paraprofessional and the client. On this one, we actually thought there was a lot of benefit between for this particular program. And so we actually have said that for that, we actually, we still have that same concern about it not being public, but it was a fee dispute. So we really thought that this should be something that's used for paraprofessionals, that they should be allowed to go into that process and have an outcome based on whatever the arbitration comes out with. So we really did think that that was something that was important to be used. The other one that we looked at was hybrid reprovals. These are actually similar to that alternative agreement in lieu of discipline, but they are considered discipline. And we, again, that basis that we thought anything that's discipline should be public. So we decided we don't think these should be included in the paraprofessional program. And then the alternative discipline program. So this is a program that really helps attorneys facing substance abuse or mental health challenges. For the attorneys, it's actually funded by a portion of licensing fees. And while we had some concerns about the program itself and its process and whether it's really protecting the public, just looking at it, I think we were kind of thinking that it has some advantages, it also has some disadvantages, just really because of the number of individuals at this time that will be entering this program. We think this one kind of should be on hold. We don't want to move forward with implementing it, especially in the pilot program, and maybe there's an advantage for it in the future that we may need, but at this point, we decided that we don't think that there should be the alternative discipline program. So I think that's all of the different types that we discussed. I don't know if we want to stop there or we want to actually go into, maybe it'd be good because we are talking about these things to go into the public records on each of those types of decisions that we made. So for warning letters, just to let you know, because of what they are, it's not discipline, it's not action you're taking against the licensee. It really just is that. It's a warning to the individual. Those would not be published, they would be private, and they would, no public members would be available to get a copy of those. The citation and fine program, we actually believe that because it is a citation, it is a fine, it's been issued, even though it's not discipline, it should be something that individuals are aware of because you did find a violation. So we think of it, it should be actually available for 3 years from the date that the complaint or the citation is resolved. And so if that occurs, it would be on the website. And so it would be on there for that 3 years unless it was withdrawn or dismissed as part of that. And when it goes back for appeal, if it gets appealed and it gets withdrawn or dismissed as part of that process, then it would come off the website. But then after 3 years, it would actually transition to private, but it would be in the file indefinitely. The notice of disciplinary charges, which is the original document when you're charging for discipline against the licensee, we actually think that that should be public. And again, unless it's withdrawn or dismissed as part of the outcome through settlement or through a hearing. If that happens, then it should come off and basically it would be on the website when it happens, when it gets issued, but it would only remain on there unless if it's withdrawn or dismissed. But then at the next point, it's going to stay on there for the duration of the discipline charge. So you can see kind of down below, we're going into public reproval, which is on there for 10 years. So that notice of disciplinary charges would only stay on the website for the length of time as the discipline, as well as it would be for the duration of the period underlying the discipline being public as well. If you could call in or write in for a copy of it. The public reproval, which is like a public reprimand against an individual, that's one of the types of disciplinary outcome for an individual. We believe that should be public, but because of what it is, these should be issued really for a lower level of violation or minor violations as well. Because of that, we thought that it really should only be on the website for 10 years, and then it's only public upon request. So an individual could write into the board, but it's not going to be on the individual licensee's web profile. For the next two, which is basically probation and an interim suspension, those are both public. Again, the probation is a discipline action, an outcome that happens. We think that should be on the website, and we think that should basically be indefinitely on the website. Interim suspensions, these are kind of finite. We think that they should only be on there for the duration of an interim suspension. These are not suspensions that are part of a disciplinary action. It would be like a earlier restraining order type of suspension. The suspension itself, when it's a part of a probation order, a discipline order, that is one where we think it should be on the website and it should be public indefinitely. So it would stay on there forever. And then disbarment of the individual's license, basically that would be on the website and that would be on there indefinitely. So that's kind of the outlay of all of the public records, just to where you know where we are as a subcommittee on a lot of our items. We are still looking into criminal convictions and whether they should be on the website and what that would look like. for individuals. We didn't come to any resolution on that issue. And then I know the overall kind of the big issue that we haven't addressed as a working group is putting together those discipline standards. So that's something that we need to work on. And then the final thing, one of the bigger issues, and I know that we've had questions about this, is unlicensed activity. And on that particular one, we will be working with, I think, the regulations committee, talking about what we're going to do with unlicensed activity cases and how the law needs to be written, and then what we can do after that law identifies what unlicensed activity is. So with that, sorry, it was kind of fast, but hopefully that answers everybody's questions and kind of explains what we've been doing. And Julie and Ira and Sharon, anything you have to add, please do so.
And I want to apologize for the confusion in displaying the slideshow. I've been having some technical challenges.
It's okay.
Julia, I see your hand up.
Yeah, I have a question about the public approval because as I understand it for attorneys, that is not on the website for a limited period of time. It remains part of the website forever. And that's partly because it's like in circumstances when there have been more than one successful claim against the attorney. And so it's worthy of, it's like a measure to protect the public. Am I mistaken?
On the attorney side, I believe, is that correct, Leah, that it is only on there for, I mean, it's indefinite on the attorney side?
Yeah.
I can't remember. It is.
Because, well, remember, on the attorney side, there's not a very well articulated set of rules about what's on the website versus what's public on request. So, yes.
So Julia, would still be public, it just would not be on the website. And we were just kind of not putting, something out there that was a minor, due to minor violations, just not having it out there to where it was continued on that individual's record indefinitely.
I was trying to envision it like the attorney's discipline, and I don't see that when an attorney gets a public approval, to me, it's considered a big deal. It may not be a probation, a suspension, or disbarment, but if you have risen to the level that something has to be on the website, and my impression was to protect the public, that they could look you up and find this out about you, I would think it should be the same for this professional, paraprofessional. That's my 2 cents.
And I don't want to speak for the rest of our subcommittee members, but I don't know that we would have a problem with changing that to indefinite, but more individuals would have to speak on that as well. We did that, Julia, just so you know, there some of our boards at DCA, they have real specific laws, and this is one of them for some of our boards that they have it out there for 10 years.
And I also just wanted to add, I see Amos's hand is up. Another distinction from the attorney discipline system is under this construct, there is no private reproval. And there are private reprovals on the attorney side, which are therefore not public. So part of this, it is a little different than the attorney model. I see Amos and then Ira.
Thanks for all this work. This is terrific. I just have 2 comments. One, thank you for pointing out the unlicensed activity. I do think that is an important thing both for the regulation and discipline subcommittee to work together on. So I'm glad we're going to be doing that. At a previous meeting, I raised the question about restitution as part of discipline. I'm wondering if that is something that the committee has looked at as a possibility. I know in some licensed professions that is part of the discipline process, and in others it is not. So I'm interested to hear if there's been any discussion about that.
My recollection, we haven't really touched on restitution or like conditions of a probation that an individual would have to take. I think that would probably be, and Greg, correct me if I'm wrong, but that would be maybe something we would put in disciplinary standards. So I think that would maybe be a discussion about restitution when we talk about outcomes of different disciplinary actions. That's kind of my thinking. Am I correct in that?
You are, yeah. And on the lawyer side, the Supreme Court, when we suspend someone or disbar them, and it involves either the failure to return unearned fees or some sort of misappropriation on the part of the lawyer, the court will make that part of its order. And in order to be either reinstated from suspension or readmitted into the bar, you have to meet that restitution requirement before the court will allow that.
Okay.
And just if I, and to the extent that there's been a payout from the client security fund, the restitution to the fund is a requirement also.
Ira, and then Judge Yu.
On the 10-year limit on or duration of public approval being on the website, I remember that I and others felt that since it's a low level of violation, that it seemed fair and better to have this 10-year limit. Even I understand it's not true for lawyers. I think it ought to be. But remember that on the right-hand column, the far right-hand column, it remains a record in the system, and a record that the prosecutors can look at if there's further violations by the paraprofessional, and the prosecutors could take it into account. And I still feel that way, and I think I wouldn't be in favor of making this indefinite.
Okay, Judge Yu.
Thank you. I just wanted to share, I was on the CJP, the Commission on Judicial Performance, for 9 years. And so judges also receive private and public discipline. And whenever there's any type of public discipline, regardless of the level, I mean, whether it's considered to be a lower level, like a public admonishment or a censure or removal, that is public forever. And it is to protect the public, but also it serves an educational value. Judges are able to go and read those cases and learn from them. And then some of the commission's decisions are actually even reported in the California reports. So I think there is not just the consideration of the public and then also the individual, but the educational value as well. And then also, as Ira alluded to, any private or public discipline is priorable within the judicial discipline system so that it can be used to elevate the level of discipline if somebody receives subsequent complaint, investigation, and discipline. So I think it should, if the lawyers have it there forever and the judges have it there forever, I mean, it seems somewhat protective to allow paraprofessionals to not have it there beyond 10 years.
Ira?
Yeah, so I don't want to make this a debate, but I see a big difference between judges and lawyers or paraprofessionals. Judges on the one hand, and lawyers, paraprofessionals on the other, because, of course, a judge's job or income or anything else isn't affected by having a record of discipline. Whereas a paraprofessional certainly is likely to be, and a lawyer too, and I think the rule ought to be changed for lawyers because it's a low level of violation, and if it's only, well, anyway, you know why.
Okay. I think that's all the hands we have up. We are slated today to take some votes. So Linda, perhaps you can put up the resolutions. Oh, Amos, you've got your hand up, sorry.
I just would like to see if we have public comment before we take votes.
And I'd also like to suggest, because the resolution incorporates all of the recommendations, and I think there was an outstanding issue regarding whether appeals would be heard by the hearing panel or by the paraprofessional licensing board. So I don't know if before we.
I think I was going to recommend modification of the resolution. I know because Kim has some time constraints, Amos, that was our reason for.
Well, why don't we do this? Why don't we see if any attendees have public comment that would relate to the disciplinary system? If so, please raise your hand and we will hear from you. I'm not seeing any hands. Is Linda or Leah, are you?
No.
No.
Okay, so we will take public comment after we're done with this. But at this juncture, let's go back to it since we don't have comment that relates to it.
So Linda, if you could put up the resolution. I'm wondering if what we could say with respect to the first one is with appeals to be heard by either a 3-person panel or a paraprofessional board, and talk a little bit about the decision-making process. I do think there may be some fiscal implications of having 1 versus 2 panels. And because we've started to talk about that with the interim executive director, just the overall cost of the program and how we're going to finance it, I think that may be a factor that might inform ultimately if we have 1 or 2 hearing panels versus using the board. So I'm wondering about a resolution that says this, that essentially leaves to the discretion of the discipline subcommittee working with staff to make the final determination, if folks would feel comfortable with that. Comment.
I'm fine with it.
Okay, Ira.
Ira has his hand up.
Yeah, it occurs to me that that decision ought to be by the full working group, just like this is. I presume this resolution is for the full working group, right?
Yes.
You know, I think that decision should also be.
Okay. Is someone prepared to make a motion then on either the 3-person? So right now this is either.
Well, I know it says either. I think part of the problem with the way it's currently written, Leah, is that it says either, but it doesn't say who would determine that.
No, really, the way this was originally drafted, Linda just edited it. It presumed that this group was going to make a decision today and we would strike one of them. And
Right.
then I just suggested this either. It sounds like Ira's not comfortable with that. Or
yeah. And you feel, and just to reiterate, you feel that we cannot make a decision today. Why?
No, maybe we can if someone wants to make a motion. Yeah.
No, in regards to why you think we have to leave it open as to being a 3-person panel or the licensing board, why do you think it needs to be an either or at this point?
I didn't feel that the group was ready to, there wasn't much discussion about it. So I was concerned that folks weren't really ready to make a recommendation. And there may be a sort of a fiscal implication that is only beginning to be fully fleshed out. But really my concern was there wasn't much discussion about it at the last meeting or this one. And are folks ready to take a vote? I don't.
Yeah, so I think I kind of agree with Ira then. I mean, I think either we've discussed it and we're ready to take a vote on it, or we haven't discussed it and we don't take a vote on it. And so I guess the question is whether, I mean, is Kimberly still with us? Kimberly, do you want to chime in on this?
Yeah, I think from our perspective, where we were looking at is what we don't know the composition of that paraprofessional board. I think the fiscal implication, like Leah was talking about, is if the hearing panel, they're going to be paid a different amount probably than a board. Usually boards are right; they serve on a board and it's a minimal per diem. At least that's how ours are. It's not as much money as you're going to pay this hearing panel. And so the hearing panel would probably be more expensive. I think having the licensing professional, you're going to have more opinions. This is just kind of pros and cons of each side. From the paraprofessional licensing board, if it's made up of, I think last we were discussing, correct me if I'm wrong, Linda, I think we were at like, were we at like 13 members? Is that about right? So you're going to have a larger group reviewing it, that appeal level, and you're going to have more opinions. So it definitely has some benefits to having the board reviewing it, because you're going to have more individuals looking at that and making sure that they all join consensus, or that they all have an opinion on it. So I mean, there's definitely some benefits to having it as the board rather than a hearing panel that you're going to have to be paying probably more money for.
But putting aside the money piece of it, it sounds like you think that what is your view? Let's put aside the money piece, okay? That's not relevant. Do you have an opinion as to whether it's better to be heard by the panel or the board? And I heard you say that the board would certainly allow for greater input given the larger number, greater number of people on it.
Yeah, I mean, I don't want to speak for our whole subcommittee because I don't think we ever actually came to a final resolution. I think we wanted to bring it to the working group to discuss. My opinion is I think a licensing board can make that decision just because I have experience with licensing boards. And so my opinion is they would be, especially at the appeal level, it's already gone through one level of review. I do think that that's an appropriate review for them, but don't want to speak for my other subcommittee members. Yep.
Yeah, and I was asking you, not so Erica, I see your hand up.
Thank you. I was happy to go with what Leo suggested because I thought there was a cost issue. But if we take out the cost issue, I think a professional licensing board is a good place to have that final appeal. And in some ways, it models the CJP because the CJP has a 3-person panel of special masters who sort of hear the facts and make a decision, and then that decision goes to the full commission, which is basically like a jury of 12, although there's 11 members, and here would be maybe a board of 13. And depending on that, the licensing board's composition or task, I think it would be interesting to have the licensing board, which sets forth the standards, actually be the one to determine were these standards violated, were they met, what should be the level of discipline for violating that. So I was leaning to the paraprofessional licensing board, but I wasn't sure if it was the actual time to make that final decision. But without cost, that's why I think that would work better.
Okay, thank you. And I think this is part of our having the conversation now to see whether can we vote on this or not. Okay. So Julia. Julie, I think your hand's up.
I was on mute, sorry.
Okay.
I agree with Judge Yu. I wanted to raise that point as well. I agree that if we're not taking in considering costs, and I think the licensing board is the better body and would agree with that. With respect to the public approval, I don't know if we can fashion a statement to the effect that it can be on the website for 10 years. But, if there is an actual case, I like what Judge Yu talked about, if there is something that has an educational value for the license, for the paraprofession, I really think the education coming from a regulatory body would be very helpful to that group if, for a fact, people start walking into trouble in the very beginning. I think it would be instructive to their colleagues to be learning from their mistakes. Now, others may have it, not agree with wanting to make them the focus of some public consideration, but I did really like what Judge Yu said about it being for an educational purpose, and considering we're just starting this out, anything we can give to paraprofessionals to make them better professionals and ethical, I think would be helpful.
Thank you. Stephen Hamilton.
My question would be, would we give the licensing the board the ability to summarily, I don't know if we would include this in the legislation part of it, or this would be something to decide, but I would want them to have the ability to summarily deny or summarily grant an appeal. Granted, if there was some error, procedural error, summarily denied if the facts are so overwhelming that giving them the kind of the same power that the state Supreme Court has with regards to attorney complaints and discipline.
But I think on the attorney discipline side, not I think, there is the hearing level and there's the review level. And I don't believe that at the review level, there's, I think there is a right to that review. Greg, correct me if I'm wrong.
There's my unmute. Yeah, so attorneys and OCTC have the right to review at the review department level. From there, they can move on to the Supreme Court, but that is a discretionary level of review.
That's giving them the same. So what my suggestion is giving them that same level, that not forcing the paraprofessional licensing board to hear every single review of an appeal or appeal from an appeal, the secondary appeal. The model I saw, I thought it was going to be that you would have the situation reviewed and you had a right to appeal that. That was absolute. That was the 3-panel. The step after that, I'm suggesting, if that's going to the licensing group after an appeal panel's already heard it, I think the licensing board should have the ability to summarily deny or not grant a hearing from the appeal.
Kim, maybe you want to clarify. I think it is are you going to clarify?
Yeah.
Okay.
So the thought really was that second level review, they would take all of them. They would be required at that point. It's the Supreme Court then that would have the ability still, because you would still have one more layer to go, that they would be the ones that would have the ultimate ability to hear it or not.
Because Stephen, it's not an appeal panel and then the board. I think maybe that's the confusion.
Okay, the flow chart made it look that way to me. I'm sorry.
Yeah.
Okay, yeah, no, we're trying to make that decision today. Which one is it? There's several other hands. Oh, 2 hands. Do you want to?
Yeah, let's take her from Ira and then Erica, please.
2 things. First, I think I didn't make myself clear about what I favor as far as voting right now. I do favor making a decision by vote today on the resolution. But what I think is that in the end of the first paragraph, it should still say to be heard by a discipline subcommittee or whatever. No, with appeals to be heard by, it's gone now, but it's that committee or the paraprofessional licensing board, parentheses, the choice to be made by further resolution of the working group. My second point is that as far as the education value of public approval being remaining public indefinitely, I can see that point, but after 10 years, the record could be anonymous. The educational value is there with or without the person's name. I'm done.
Actually, Ira, that's what I was going to suggest, that if we were not micromanaging, I think I was building on what Julia said, that perhaps after 10 years, we could delete the name of the actual paraprofessional and leave the lesson.
Right, and I totally agree with that.
That works for me.
Kim?
I was just thinking, I'm sorry, I'm not familiar enough with the bar to know, do you have like a posting where all of your disciplinary actions get posted?
No,
like a newsletter or a?
They're associated with a record right now, but
okay.
It's something that could be implemented.
Because maybe to everybody's point about the education, that's maybe one thing that we talk about for the paraprofessionals, is that there is a place where all of them would be listed, because there's a lot of value in looking at any disciplinary action, unless you know the name of an individual, it's hard to go see that if you don't know that somebody's been disciplined. So it might be good to have that just to start anyway. One of the processes, this isn't something we have to decide as a group, but a process is that you're going to post somewhere all of the disciplinary action, whether it's in a newsletter or something, because of that educational value.
Can I just share, the CJP actually does do that, and there's like a drop down menu. If you want to look on any discipline on ex parte communications, you go right there and you can look at it subject matter by subject matter. So it is very instructive.
Greg?
I just want to point out for the group, not that it should affect the recommendation here, but it may be one of those things, one of those statutes that needs to go on the list, because with private approvals for attorneys, the level of public disclosure, the extent to which it's made public depends on where the case is. So if a notice of disciplinary charges have not been filed, and there is a plea bargain, for lack of a better term, between the attorney and OCTC, and they agree to take a private approval, that is not made public, and it doesn't appear on the State Bar's website. And the reason for that is because by statute, under the State Bar Act, investigations of attorneys on complaints remain confidential until charges are filed. And so the State Bar is constrained actually from making that information public. That doesn't mean it's not part of their official membership, and it can become public as a prior record of discipline if that attorney is subjected future discipline for additional misconduct. But we don't have a statute for paraprofessionals that requires that their investigation of any complaint remains confidential. So that statutory constraint isn't there right now.
Okay, I see Kim and Judge Yu, and I'm hoping someone is going to make a motion.
Well, so yes, I think we will get to a motion, but I also think it's important that we fully flesh this out. So let's hear from everyone and then see where we are.
Kim took her. I don't know if Kim's hand is up or down.
I just wanted to say that as in regards to what Greg was saying, I think our intention when in our group, our subcommittee, was that we would have an ability, Greg, to issue a pre-notice of disciplinary charges, public reproval, and one that could happen after a notice of disciplinary charges, to do both of them. And we would potentially write the law to where it would be, or the regulations to where it would be able to be public either way that it happens. So that would be a little bit different than what the attorneys can do right now, which kind of goes to our point of why we want them on there for 10 years, because it might not be one that is attached to a notice of disciplinary charges.
Judge Yu?
Erica?
Yeah, if we were ready, I was about to make a motion, but I took my hand down earlier because I wasn't sure we were ready.
I think we're ready now if you'd like to make it.
I will make the motion that the resolution, which is currently being displayed, be adopted.
I'll second that motion.
Okay, Linda, can you take the roll?
Yes. Okay. Bashan,
Yes.
Ernelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper. I'm not sure if you've joined.
I don't believe so.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson. She's still absent. And I think Judge Rubin is absent. Shining,
Yes.
Sarouche. I think she is absent as well. Spiro,
Yes.
Torres Ambris, not present. Judge Wiley,
I don't believe she's present.
okay. Judge Yu,
Aye. Thank you.
okay. And I think the chair generally doesn't vote unless there's a tie, but we don't have a tie and the motion carries.
Thank you. Thanks, Kim. Should we move on, Justice Patrick?
I think we should move on to public comment and then we can move into our next subject matter.
All right, anyone wishing to make public comment, please raise your hand.
And did you want to set a time limit for public comment?
3 minutes.
Okay. We just need to get set up to time. Okay, the first one is Tom Gordon.
Thank you. My name is Tom Gordon. I'm the Executive Director of Responsive Law. We're a national nonprofit working to improve access to and affordability of legal services. I've spoken before and provided written testimony on various topics to the working group, including fee caps for paralegals, which is a topic that I know is still under discussion. And as we've said before, fee caps are a solution in search of a problem. Lower prices are going to be one of the main selling points of this new profession. And so the working group and any future regulatory body for paralegals should focus on areas where consumers need protection and not waste resources on trying to regulate fees. I'd like to give some examples of what a regulator would have to do in order to create and maintain a set of fee caps. First, looking at hourly rates. If just to regulate hourly rates and set fee caps, you'd have to look at, for starters, experience level of a paralegal. If you use the Laffey matrix for lawyers as a parallel, you've got 5 different tiers of experience. Then you'd probably want to look at geography as well. You'd certainly want to have a higher fee cap for San Francisco than you would have for, say, Crescent City. So if you look at 9 economic zones in California times 5 different tiers of experience from the Laffey matrix, you'd have 45 different hourly rates to set. And then look at something like service, like turnaround time. If someone wants a document prepared in 24 or 48 hours versus 1 week versus no time issue, you could have another level of complexity, adding 4 or 5 different types of fee structures just for an hourly rate, getting up to a few hundred different types of fees. But as they say on game shows, that's not all. What about flat fees? If you're looking at flat fees, consumers benefit from having a total cost up front that they know about, but regulators would have to set fee caps for all the possible flat fees a paralegal might offer. So for example, if you're drafting a marriage dissolution, are you going to have a fee cap for with children and without children, for lower assets, minimal assets, for one with home ownership involved, one with complicated division of assets? What about custody agreements? If both parents are in California versus if one parent is out of state, versus if one parent lives abroad, versus if it's a same-sex couple with one member living abroad in a country without recognition of same-sex marriage. Lots of different degrees of complexity would result in lots of different needs for fee caps. Visitation agreements. Regular visitation agreement. What about a supervised visitation agreement? What about grandparental visitation? Supervised grandparental visitation. Visitation for out-of-state grandparents. Visitation for foreign grandparents. And that's just looking at one area of the law that we'd be looking at. You'd look at name changes. You're looking at landlord-tenant issues. You're looking at a lot of areas where you could come up with thousands of permutations. And I don't think a regulator's time is best spent on micromanaging the charges that someone might charge when this is not likely to be an issue for consumers who are already going to be seeing low prices from this profession.
Thank you. Your time is up.
I think we're ready to move on, Linda.
Okay. Next is Johanna Baumann.
Hello, thank you. My name is Johanna Baumann. I'm from Betzetic Legal Services in Los Angeles. We do appreciate the committee's consideration of the need for rigorous oversight of the proposed paraprofessional program, and we urge you to keep in mind the need for strong consumer protections. We believe that this program should contain clear guidelines for ensuring that those eligible for free legal services are made aware of that option and are being directed to organizations that can and will handle their legal issues. There are continuing concerns about the lack of attorney supervision for paraprofessionals who, under the current proposals, would be allowed to represent clients on issues that affect basic needs and can have huge implications on their well-being and quality of life. As well, we have concerns about the State Bar's current capacity to provide meaningful oversight. The State Bar's Office of Chief Trial Counsel should be participating in these meetings as a current regulator of non-attorneys in the unauthorized practice of law, so that they can specifically speak to their role in the oversight process, as well as that of other regulatory agencies, such as city attorneys and district attorneys. What expansions or amendments are necessary or advisable to current regulations preventing non-attorneys from engaging in the unlicensed practice of law, and how Business and Professions Code section 6126.3, the section that specifically gives the State Bar jurisdiction in California civil courts over non-attorneys, may be applied to paraprofessionals. It is essential to involve a representative from OCTC to discuss their capacity for handling the regulation and discipline of this proposed program. Additionally, in the State Bar's own proposal for the paraprofessional program, it cites the justice gap as a motivating factor in the implementation of the program and states that a regulated paraprofessionals program can expand the pool of available and affordable, trained, capable providers of legal assistance and help narrow the justice gap. Given the State Bar's stated mission of consumer protection, affordability should not be left to the markets. Rather, we believe that fee caps must be part of this program and suggest that the State Bar and California legislators look to the DOJ's Executive Office of Immigration Review regulation of non-attorney immigration representatives, which requires the submission of a fee schedule for
We have 30 seconds left. Thank you.
fees charged to ensure that services are free or low cost. Thank you. I appreciate your time.
Okay. Next, we have Jason Solomon.
Hi, Jason Solomon, Stanford Center on the Legal Profession. I just want to make 2 quick points about fee caps, which I understand from the last meeting still under consideration. I understand the rationale behind them, share the goal of making sure these services are affordable, but I don't think this is the right mechanism to achieve the goal for 2 reasons. One, putting potential antitrust issues aside, I just think it would be poor optics for the State Bar to set caps for paraprofessionals and not lawyers. As you know, the bar as an agency often criticized for being too cozy with lawyers. That's why the legislature separated the regulator from the trade association and added public members to the board a few years ago. We now have the high-profile case of Mr. Girardi, which I realized was under prior leadership. Nonetheless, in this context, I think it puts the State Bar Board in a tough spot to recommend to them that we set fee caps for paraprofessionals, a group, by the way, that is more likely to be women and people of color than lawyers in California, and not have comparable fee caps for lawyers. The second reason is that we want and need paraprofessionals to get their licenses and be able to make a living. And we don't really know how many cases and what price they will need in order to make a decent living. And that will quite likely vary depending on whether you're in the Bay Area or LA or the Central Valley. And to the extent we signal that it may be difficult to make a living, we risk not getting enough paraprofessionals to actually achieve the goals of the program and improve access to justice. Now, this is very different than another context where we do set fees, which is court-appointed lawyers. Now, in that context, lawyers decide to get their license. They build a private practice. Maybe you're a solo practitioner, you do some criminal defense, you do a bit of personal injury, you do a few wills, and then you can decide how many court-appointed cases you want to take on to supplement your private practice based on your existing caseload, how much you will make from court-appointed cases, et cetera. This is much different. If you want to make a living, you need to accept these fees. And if you need to make more money, your only choice is to increase your volume of cases. Now, if you were a lawyer in this situation without the constraint of fee caps, you might say to yourself, you know, I'm going to try to increase my fees a bit, but not take more cases, because if I take more cases, I'm not going to do as good a job on each case, or I'm going to run myself into the ground and my practice and life are not going to be sustainable. But if we have fee caps, and paraprofessionals are not going to have that option. They just need to increase volume if they need to make a bit more money. And I don't think we want to put paraprofessionals in that position in the absence of real evidence that excessive fees are going to be a problem and that the market won't take care of it. Thanks very much.
I don't see any additional speakers.
Thank you to the speakers. And are we ready to roll into our next subject?
Yes.
Okay. And do we have, here we go.
Are you taking the lead on this, Amos, I think?
Yes, I can take this on.
Thank
Okay.
you, Amos.
Yes, so next we have the recommendations of the regulation subcommittee. There are a number of items that the regulation subcommittee is looking at, and we provided a report talking about the progress. I believe it was included in the materials. It's a February 26th report. I will give an overview of that. The two items that I believe we are ready to put up for a vote are the MCLE proposal and the financial responsibility proposal. There are a number of other items, including some of the items that were just discussed in public comments related to fee limitations or unauthorized practice of law by non-licensees, as well as a host of other issues that I will give an overview of that we are not ready to make recommendations on at this time. They are still under consideration. So let me start with the two items that we are ready to make a recommendation. First, MCLE and the slide for financial responsibility. We did cover these at length at a prior full working group meeting, but I'll give a quick summary and happy to answer any questions. For MCLE, the regulation subcommittee felt that MCLE is an important aspect of a proposed program. It's one of the main ways for continuing education and competence, similar to how we do it with attorneys after the initial training and licensing requirements. We are proposing 36 hours every 3 years. 28 hours of that is in the paraprofessionals practice area. The 4 hours on legal ethics track the attorney requirements, same with the 1 hour on competence issue and 1 hour on elimination of bias. So those 6 hours, the ethics, competence, and elimination of bias, track the attorney hours. We did add, and this is a difference from our prior recommendation, 1 hour of trauma-informed practice and 1 hour of practice management running a business. So I'll go a little bit more in detail on that. We also changed our proposal for how much could be obtained through self-study. Some of these changes related to comments that were received at the last meeting, but we tracked the half could be done by self-study, which now is 18 hours that could be obtained through self-study. So our recommendation, and more detail on this is in the report, but we did look at a number of things to try to identify the appropriate number of hours and specific requirements for MCLE. We looked at a couple other jurisdictions. We looked at what the requirements are for California attorneys, and we designed our recommendation to balance the not to be too burdensome, but to have some effect on continuing education and competence concerns. So 36 hours every 3 years is, of course, an average of 12 hours per year. In California, attorneys are required to do 25 hours every 3 years, which is about 8 1/3 hours on average per year. In Arizona, paraprofessionals are required to do 15 hours per year. In Ontario, paraprofessionals are required to do 12 hours every year. And in Washington, the LLT program, it required 30 hours every 3 years. That's on average 10 hours a year. Of course, they had higher initial requirements, both for education and experience. One of the main factors, as we explained in the report and at the prior meeting, we looked at California attorney specialists. They are required to do 36 hours every 3 years, and we thought this was the most parallel to attorney specialists that advertise that they specialize in a particular area. So that's where we ended up with 36 hours every 3 years. Technically, we were told that attorney specialists in California, actually their requirement might be as high as 42 hours every 3 years because of what they're allowed to count towards the basic attorney requirement. But we did not increase it to 42 hours. We kept it at the 36 hours, which we thought was appropriate. We have talked as a full working group on the trauma-informed practice before, but just to remind people, we felt that this was appropriate, not just in the family law area, which it was initially recommended, but across all practice areas as sort of the best practice for people who are practicing in these practice areas and with what we expect to be the likely typical clients for paraprofessionals who are experiencing trauma and dealing with significant issues for them. The 1 hour of practice management and running a business came out of our discussion, which we'll get a little bit more into about proactive management. We tried to identify areas where we could proactively try to avoid problems. And one of the areas that kept coming up was paraprofessionals are going to be out there starting a business and may not have training starting a business and running their own business. And so having some sort of required training on that is sort of a prophylactic matter to try to avoid problems where we expect they might occur. So that's 1 hour required every 3 years. So we thought that was appropriate. I think that's it on the MCLE update. I will jump into the financial responsibility proposal. Again, we talked about this at length and it's in our report, but as an overview, the regulation subcommittee feels that financial responsibility is a necessary and required critical part of a proposed paraprofessional program. It was one of the recommendations by the ADLS task group, and when we looked at it, we decided it was a basic required part of the program for consumer protection. We looked at a number of different possible ways to provide for financial responsibility, mainly 4 ways. A bond requirement, malpractice insurance, the client security fund, and proposed possible restitution fund that could be created. We ended up with a proposal for a required security bond. And I'll talk about the amount, but we ended up proposing a $100,000 bond amount, which is the same as what's required currently for immigration consultants and some other licensees in California. A bond is a common way. Oh, thank you. So the slide shows up just some selected. There's obviously a lot more different licensed professionals, but in California, a bond requirement is a common way to provide financial responsibility for licensees. There is a bond requirement for immigration consultants, for legal document assistance, for unlawful detainer assistance, for notary publics, and we're sort of tracking that model. Bonds are less expensive than malpractice insurance. They are different in fundamental ways, but they do provide some protection. The bond amount is a total amount that the surety is responsible for, not a per claim amount. So large claims or multiple claims would reduce or eliminate what is left on the bond. The cost of a bond is about 1 to 3%, and they can be issued for multiple years. So we looked at least as compared to requiring malpractice insurance, bond is cheaper, easier to get, provides meaningful consumer protection. So that is where we ended up. Just a little bit more on malpractice insurance. We did not come to an agreement on requiring malpractice insurance. Malpractice insurance obviously would be a best practice. It provides additional and different protections than a bond. So it still is something that could be obtained in addition to a bond. We do think that would be a best practice, and we do have a recommendation that's similar to attorneys. There would need to be a disclosure if malpractice insurance is not, if the paraprofessional does not have malpractice insurance, but we are not recommending that malpractice insurance be required. If you could go back to the prior slide, with the client security fund, attorneys have a client security fund, and we are recommending that paraprofessionals also have a parallel client security fund. That is for intentional wrongdoing and theft. It's limited. It's based on a fee from the licensed paraprofessional or licensed attorney. So we do recommend that parallel to the attorney client security fund, that there be one for paraprofessionals. It is limited. It doesn't replace what a bond or a malpractice insurance would cover. One of the issues that was raised of concern about the client security fund that exists for attorneys is it takes a very long time to get payouts from that. It requires discipline findings, usually, if not criminal findings before payout. So we are recommending streamlining that process and not requiring a discipline or a malpractice judgment or criminal conduct in advance of a payout. Our committee suggests, because we realize that it not only goes to this full working group, but also goes to the bar and maybe beyond before a full paraprofessional program is instituted. So our recommendation also includes that if neither a $100,000 bond or malpractice insurance is required, the bar should create a restitution fund to compensate for both intentional acts and negligence. Our recommendation is not that that should be included. It's that if a $100,000 bond or malpractice insurance isn't required, there needs to be some system for financial responsibility. So that is an alternate. We heard from people who basically said creation of that kind of restitution fund would be expensive and administratively difficult, and that a malpractice insurance or a bond requirement is a better choice. So that is why we ended up with that recommendation. I think that's it. Let me just talk about the bond amounts, if you don't mind going to that other slide. So our recommendation is a bond amount. There was then the discussion and decision on a proposed amount of the bond. We felt that the immigration consultant bond is the most parallel to what exists, because immigration consultants, effectively provide advice on important matters. Legal document assistance, their bonds are less, but they're not providing legal advice. And the risks of harm and injury to clients is increased as we increase the practice areas and we increase the responsibilities of paraprofessionals. So we felt the $100,000 bond is the appropriate amount. We also looked at the cost, and we wanted to make sure we weren't creating an undue entry into the profession. We did not find there would be a significant difference if we lowered it, for example, to $75,000 in the cost, and it would obviously provide significantly less protection. So that was something we considered in determining the $100,000 amount. There are a number of other areas, as I mentioned, that I think I would like to update the full working group on with respect to what the regulations subcommittee is working on and is considering. I don't know if you have a slide for the table 1 in our report, but I think it might make sense for us to focus just on these two first, because we're recommending a vote on these and discussion separate from the other issues. But I'll just tell you generally, the other areas where we are also working are written agreement and mandatory disclosures, and we have some draft language in attachment A to our report. Informed consent requirement, scope of practice and prohibited acts, advertising limitations, fee limitations, proactive risk-based management, regulation, which I think we will talk about more, and other areas. One issue that has come up is a determination of the name of the licensees, which we feel is important, and I understand that's going to be handled either by the full working group or a separate subcommittee.
Well, Amos, let me just jump in for 1 second. Lee and I have had some preliminary discussions about that and have started consulting with someone, and we'll put together a plan, but just everyone know, we're focused on that and trying to move that forward.
Perfect, because we did at the regulation subcommittee, just so everyone knows, we did find that or would recommend that it makes a big difference what the name of the program is in terms of public protection and potential misleading of the public. And also evaluation. So one of the things we identified, of course, there's going to be a need for evaluation. That was a preliminary discussed by the pilot subcommittee. It relates to regulation because we have to decide what kind of data we're requiring paraprofessionals to provide. And so we're still working on that, and maybe there might be room for a separate subcommittee specifically on evaluation. So with that, I guess I'll defer to you as a chair if you want me to give that other report, or if you want to focus on what we're recommending for a vote.
Leah, what do you think?
I think it would probably make sense to vote on these two and then maybe
Hear further.
Yeah.
Yeah, it's fine with me.
Do you want to pop up? Okay, we have some hands up, and then maybe Linda, while we're doing this, you could put up the resolutions. Ira and then Carolyn.
This is one thing it didn't occur to me till just now, and I have listened to the meetings of the regulation subcommittee. It's the cost of the $100,000 bond, and Amos said that it could cost 1 to 3%. It does cost apparently 1 to 3%. 3% is $3,000, of course, and that's a lot for somebody starting out in a business anyway. And I think too much, particularly since this is probably, I think, like malpractice insurance, where in your first year, the odds of there being a claim are pretty low compared to years out, because things don't ripen quickly enough. So I think that the bond should be lower, or maybe not required at all, but maybe lower, say $50,000 for the first year, and then the 100 after that. Thanks.
Carolyn and then Elizabeth.
I just have a short process question. I'm always about process. Not necessarily with regard to these reports, but just in general. Are we able to, as a committee, or is there a mechanism to go over specific parts in terms of the vote? Are we going to up and down all these different areas throughout these various subcommittees? Is that, or will we be able to move to amend, that kind of thing? Maybe that's directed to the chair or to Leah.
Well, Leah, I mean, let me just say, I think that as much as we can, vote on things up and down rather than taking a million sub votes, we're better off. Also, because when you're talking about a particular area, to understand what it's going to look like more as a whole is sometimes necessary in order to vote. I sometimes don't know that I would be comfortable with tiny votes, for lack of a better term, without understanding what the greater landscape is. I'll turn to Leah as far as process questions, but I mean, I don't know why there would be an inability to amend if we saw fit.
Right. Maybe I'm not fully understanding your question, Carolyn, but any member can obviously recommend an amended resolution.
No, I think it's just talking about going forward. So for example, if we were to take a vote on something today and it passed, is there some ability in the future?
Sure. I don't see why not.
And then just to follow up, would you be able, I think in the last round of the substance areas, some people put together dissents. And so will we be able to, on these three areas, regulation, licensure, discipline, to, if we want to, just put together dissents, make partial votes, partial, I vote for this, I vote for that, when we do get to those dissents and then the final report.
So the final report from the working group to the board can include any dissenting statements or opinions or positions of individual working group members. Again, I'm not sure I'm totally clear on what you mean with respect to putting forward dissents at a particular meeting of the working group. I think that would be a no vote. But you can fully explain and articulate the basis for your dissent in the final report of the working group and clarify what you agree with and what you don't agree with.
But can we do that at these stages? Could that be we had final reports on the different substantive areas and not everybody agreed. And we put those dissents in the sub reports. I just worry that it'll be hard to track if we wait until the final vote, the
Well,
final
but
report?
I don't think we can, I mean, Leah can correct me if I'm wrong. I don't see how that would work on an ongoing basis. I think it's unwieldy, and I think it doesn't make sense from the vantage point that maybe, you know, things could change again before it's in the final report. I think there needs to be clarity about what the final recommendations are, and anyone who wishes to dissent is free to do so. But I certainly am not going to direct Linda or Leah to be trying to keep track on an ongoing basis, vote by vote, everyone's opinions regarding sub-issues. I think it's simply unwieldy. If, you know, has been discussed before, it's great when the votes are unanimous. You know, that's great, but it doesn't need to be. And no working group is going to have unanimous votes on everything. It's perfectly fine to vote no. And if you disagree with part of it and therefore can't say yes to the whole thing, vote no. But I think it's on the individual members to keep track of their own opinions and make sure that they're heard, you know, when things get finalized. Now, Leah can tell me if I just completely got this wrong.
No, but I would note that there are often sort of dissenting views reflected in the memos that the subcommittees are putting forward, and those memos will all be part of they are part of a formal public record, and they will be appendices to the final report. So to that extent, that those views are being captured and will be reflected.
Okay, that answers my question. Thank you.
I think it's Elizabeth and then Ira.
So I just wanted to mention that there are some qualified members of the public who have been interested in the immigration consulting bond, and but they've talked about the cost is prohibitive because it can range anywhere from $1,700 for the experienced business owners up to over $7,000 for those who have low credit or less experience. And so another thing that I've seen in, you know, the Facebook groups that I'm associated with, the LinkedIn groups, is they don't want to, even if they were able to come up with the money and they wanted to do this to help their communities, the fact that this might be a pilot program will deter them from taking that cost because they're going to feel that this program is not going to be here in 2 years. That's just one thing that they've mentioned, like with the immigration consulting. So I think that's going to be another good reason why maybe we want to reduce the cost. Yeah, that's just my 2 cents on that. Thanks.
Ira.
I'd like to do this either now or after we vote. Here's what I mean. I don't know the proper procedure. I'd like to make a motion to amend the proposal to make it the bond requirement 50,000 for the first year, 100 thereafter. I could make it now, or we could vote, and if the vote is yes, then I'd make a motion to amend what we just passed.
So before we talk about that procedural issue, let me just respond to the cost issue and the bond amount, because it is something that the regulation subcommittee looked closely at, and the cost. And we did have some speakers from some bond companies come and talk to us about how that fee is set and what considerations go. I think anything over this is what we heard, anything over a $25,000 bond likely does have some underwriting. So why there is a range from 1% to 3% does, it likely is impacted if there's somebody with low credit or past judgments against them or disciplinary issues that they've had in the past. That is something that goes into that, you know, range of price that is estimated at 1% to 3%. We did look at potentially reducing it to $50,000. Our analysis was that did not, $75,000 or $50,000. Our analysis was that does not significantly reduce the price. It would have to be $25,000 or less to avoid the underwriting component, is what we were told. Obviously, $100,000 bond versus a $50,000 bond does provide significantly different consumer protection, which is the financial responsibility aspect of why we're proposing this in the first place. I think our recommendation as a committee was, if there's not going to be a $100,000 bond, there would need to be some other aspect of financial responsibility, because we didn't think less than a $100,000 bond would be sufficient. So whether that is mandatory malpractice insurance or some sort of restitution fund, our recommendation is there would have to be some other financial responsibility requirement if there's less than a $100,000 bond.
So to you.
So Amos, I have a question for you and your subcommittee. And it may be cutting too finely, but did we consider maybe a different level of bond for different subject matter areas? Because for family, perhaps it needs a bigger bond, but maybe for unlawful detainers, it doesn't. Or maybe the paraprofessional entering can decide, I'm going to cap myself to 20 cases my first year, so that if they self-regulate to have a lower case level, maybe their bond level could be less because they're not having as much exposure. And that might be inviting, as Elizabeth said, to have people come in. But I am hearing you, because I was formulating my thoughts, and then I heard you say, well, it's not really going to make that much difference in terms of the cost of the bond unless it gets down to 25,000. But maybe 25,000 is enough if you only take, in the beginning, you only take a certain number of unlawful detainer cases. I don't know.
So we did look at, not exactly in that framing, but we did look at, and actually initially started with potentially consideration of a $25,000 bond. That is the level of consumer debt we are looking at in the consumer, because that's the limitation for limited civil jurisdiction cases. When we looked at it, we had some speakers and we had some discussion determining that the $25,000 is not enough because it isn't a per claim amount. One of the considerations was, so it can quickly disappear. We have heard from commenters on the immigration consultant bond of $100,000 that there's concern that that's actually not enough. There are some significant problems, and those bonds do not. There have been a number of cases where the $100,000 bond is not sufficient. So we did not, I think, look at it exactly as you're saying, but we did consider lower amounts of bond, particularly because of the cost concern and the underwriting concern, and determined $25,000 isn't enough, and there isn't a significant cost difference if you're talking about between a $75,000 bond and a $100,000 bond. One thing I'll say on the IRA's other procedural comment, I mean, to the extent there's a different requirement for the first year, I think that might be something that could be considered by the pilot committee. And I'm happy to have the regulation committee talk to the pilot committee about what the pilot program looks like and what the first year or first 3 years. That's not something that the regulation committee looked at, but for standing up this program, our recommendation is a $100,000 bond.
Can I please follow up?
Sure, and then Steve.
Okay, sorry, Steve. Thanks for your forbearance. So I know we had heard before, Amos, about sort of what is the cost differential, but could you remind me, because I'm more than ever, I'm reminded that I have to look at things beyond my own lens, like as a judge who has a good salary, maybe the differential that doesn't seem that much isn't that much, but it could be a lot for someone just starting out who has a family or is a single parent. So I'm wondering, what is that cost differential?
Fair enough. So we didn't have exact quotes. It's an estimate, but what we really heard were the determinations of cost of the bond when you're above $25,000 is there is an underwriting component. So it will depend there is a set amount for, what it would cost, assuming, no problems or no credit issues or no prior discipline, but the cost would increase if there's prior discipline or if there's credit, because it's a more of an underwriting issue. So I can't specifically answer your question. We did ask specifically about, what would the cost differential be if we were talking about a lower cost bond? And we were really told that the cutoff is $25,000. At $25,000, there's a set fee. There might not need to be any underwriting. But when you get into above that, the cost differential is going to be based on the risk.
Steve?
Yeah, I'm in favor of the client security fund. My question is that going to be a segregated fund for paraprofessionals, or is it going to get commingled with the existing state bar fund, which my general understanding, the consensus is underfunded?
Yeah, it would not be commingled.
So it would be a separate, it would be a separate segregated account. Thank you.
Separate, and I think there was still an issue that we were going to discuss of who would be making that determination. I think similar to the discipline subcommittee, there's a couple options, and one might be the paraprofessional board. But since that hasn't been resolved, I think there's still some work we have to do for defining that. But my understanding would be a separate fund.
Thank you.
Okay. Do we have anyone? We don't have any further hands up. Is anyone prepared to make a motion? Linda, can you, Judge Yu?
I'm sorry, I guess I do have another question is there a way to quantify what that small difference is between 75,000 and 100,000? I mean, I understand at 25, it may be very disparate, but it sounded like Amos was saying that there is not much difference between 75 and 100. But my thought is, I mean, let's say it's $500 difference. For some people, that is a big difference. And so I'm wondering what the quantification is for that, what we're perceiving is not a very big change.
I think it's hard, Judge Yu, because as Amos indicated, we did speak directly to bond issuers, but it's very dependent on the position of the applicant and their credit history. So it's hard. I don't know that we can give you an answer that's going to be accurate or broadly applicable.
Yeah,
so I think it's tough.
I
I'm
agree.
surprised to hear Elizabeth say 7,000. We never heard a number that high. We heard more like 1 to 3%. So that gives you sort of. Yeah.
Being in courts, I'm so used to hypothetical questions, right? That I was thinking an expert could be asked like, okay, you have X person with no credit history problem, blah, blah, blah. And then they're asked to have a $75,000 bond, same person, 100,000, and then get the number. And then another person has major credit history, blah, 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 same person, same thing, but now it's a difference between 75 and 100,000. If you compare apples to apples, that differential is knowable, I would think, but I'm not sure. And it may make a difference to some people.
Yeah, and I'll say I did ask that question because that was also on our mind specifically because we were looking at not creating undue barriers to entry into this profession. Of course, weighed against the consumer protection. So, the discussion, I'll say, sorry, Fariba's not here. Some of the discussion was that actually, there was some people who thought that actually might be a benefit, that if there is somebody with a higher risk or problems in their past, that it's appropriate that barrier or the cost is reflected in that price. And that's not necessarily a bad thing. Again, with the focus of the regulation subcommittee being on consumer protection, we shouldn't necessarily reduce the bond amount significantly because, if somebody has a higher premium because of prior discipline or something like that, that should reduce the consumer protection across the board. So we did have some discussions. I don't think we've reached a formal agreement on those kinds of discussions, but it is something that the regulation subcommittee spent some time on, both in determining that there should be a bond requirement and in proposing an amount.
Dana and then Ira.
So first, I just want to thank Amos. I think your presentation was really thorough and it's extremely helpful. I am concerned that this could be a barrier to entry, especially given that it's likely going to be a pilot program. And I wonder if we wouldn't be better off sending this over to the pilot subcommittee to get their thoughts on this.
So let me jump in regards to that. I don't know that it would actually make any difference because the way that we're doing the pilot, it's not a time limited. I think we all know this already. The pilot program is not a time limited program. Like, let's try this for a year and see if it works, which I think would be much more of an issue in order to determine the questions that are before us today. And we already pretty much know it's going to include family. It's very likely to include housing and certain collateral criminals. So we know what the subject matters are. I'm not quite sure what the point would be of sending this back to the pilot committee, because the pilot committee is not, I just don't think we'd have very much to add to this that we can't discuss as a working group as a whole. So when you suggest sending it back to the pilot committee, what questions in particular do you think might be relevant?
The barrier to entry. I'm very worried that we are establishing high hurdles.
Right, but I think that's a question for this subcommittee and the working group as a whole. I don't think that's a question that goes to the pilot committee. Leah, do you want to chime in on that?
No, I really agree with you. When Elizabeth made her comment, it made me think that we needed to revisit the fact that the pilot is not intended to be like, we're going to test this out and see if we want to do the program and we may scrap it all together. Rather, the pilot is a phased rollout or a phased implementation. So that should address some of the uncertainty that people feel. And we may want to stop using the word pilot altogether.
Yeah, because also from the licensing point of view, it's not, there was some discussion at some point about, oh, maybe the licensing requirements might be different for the pilot. It's not. The rules are going to be what they're going to be. The licensing requirements are going to, be the same. The regulatory requirements are going to be the same. It's just that it's being phased in over subject matters and across the state. So yes, I think that the term pilot gets us hung up, but I just don't, I'm not going to kick this question over to the pilot committee. The questions regarding whether the things set forth in this proposal are appropriate or not.
Ira?
Here's something that we all know, and that it didn't dawn on me until a minute ago. So some of these underwriting criteria are not good things to to measure some paraprofessional. Here's what I mean. Credit history. We all know that people of lower income have more problems with credit history than others. And that's probably true for some of the other underwriting criteria. And then finally, as far as prior discipline, in the first year, it seems impossible that a paraprofessional will have had prior discipline. So I still think the first year ought to be different.
So can I comment on that? Because I agree with you of those concerns. My recommendation, frankly, was malpractice insurance should be required. It's really a balance between the different options of financial responsibility, because I think we did have agreement that financial responsibility is a necessary component of this. And so a bond isn't perfect, but we decided it was the best of the alternatives. And we can't control the bond industry. That is just how they price their product.
Elizabeth?
Another thing that I thought of as we're talking about this is with immigration consultants, the bonding. Like, let's say, for example, in order you have to register your bond with the Secretary of State, and so you submit an application. In order to submit that application, you have to have a bond. If you are denied at the licensing level, you paid for that bond for nothing. You don't get any refunds from the bond agency. So that's one thing that we need to at least address or consider, because again, some people are afraid to make that commitment if they feel that the fact that they didn't pay their child support, a couple months ago, could affect them actually being approved. So I wanted to bring that up just for consideration. Thank you.
Julia?
I guess, I know we talked about this a little bit, but so what was resolved, Amos, when it came down to having different amounts depending on the subject matter that they'll be practicing in? What, you said you considered it. To me, that seems like the easiest solution is to determine, once we get to the subject matters, whether or not we would like to have different amounts for different things.
Yeah, so as I said, we didn't exactly cover it in that framing, but we did consider lower bond amounts. So the idea, I think the purpose of considering that would be, would it might be appropriate to have a $75,000 bond or a $50,000 bond. And what we found is with respect to the balance of the consumer protection of decreasing the amount of bond, we did not find that there would be a significant difference in the cost unless it went down to a $25,000 level. And at $25,000, it does seem like there is a difference in how bonds are priced, and that they don't have to necessarily go through an underwriting process. And so the risk of the bond price going up significantly is reduced. But we did determine that a $25,000 bond was not sufficient for any practice area under consideration.
So you assume that even in like unlawful detainers?
That's correct. We specifically considered unlawful detainers and consumer debt as the two other practice areas. I don't know that we went into everything else that's under consideration, but we were looking at family law, consumer debt, and housing. And we determined that $25,000 was not sufficient. And one correction for the resolution that's up, under the first bullet point of the second resolution, if neither a bond nor that's actually if neither a $100,000 bond nor malpractice insurance is required. We specifically discussed the concern that a $100,000 bond would not be passed either at the working group level or at the State Bar Board of Trustees. And if there is a lower than $100,000 bond, our recommendation is that's not going to be sufficient for consumer protection, and there should be a separate restitution fund that is created by the bar or mandatory malpractice insurance.
Okay, well, I was just willing to entertain the idea that we could say that the bond was not less than 25, but would not exceed 100, so that maybe we could revisit the actual number at the time we've really considered and put forward our substantive areas of law. But if others are not in, I just saw that as a way to move forward and keep this matter on the table. But if nobody else wants to consider putting in a range, then I won't make a motion to amend.
Judge Yu has her hand up, and then Justice Pitcher, we have someone, an attendee with her hand up. I don't know if you also want to consider taking that.
Let's hear from Judge Yu first.
Thank you. And Julia, thanks for trying to think outside the, framework. So I'm thinking about, let's say if we do decide we're going to include expungements, record clearance, $100,000 bond for that seems like it would not be necessary, because if the first application or petition loses, the person can just reapply. And so if we're really thinking about what Dana and Elizabeth have said about people seeing a bar where they would not be participating in the program, and we want them to participate for so many reasons, I don't know, maybe there's something in what Julie said to have a range, because if you're doing expungements, $100,000 bond seems like a lot.
Stephen Fleischman.
Yeah, Erica, let's just talk about expungements. If there's no fee cap and someone charges $10,000 to do an expungement and it fails, and they say, gee, I need another 10,000 to do it again. And then, gee, didn't work. Third time will be the charm. I need another 10,000. I mean, what you're saying makes sense if there are fee caps in place, if there are other things, but no, I can foresee scenarios where, yes, for criminal expungement, someone should have a bond in place. I think the working committee has spent a great deal of time on this, and I think $100,000 is a reasonable compromise.
Julia?
Yeah, at my college, we do an expungement clinic for free. There's also expungement clinics throughout the state for free. So Steve, I highly doubt that your average person who needs an expungement is even going to come up with the first $10,000. But I could see that. So I guess what I'm saying, I think the market is not going to create that kind of a fee structure for expungements, and I agree with Judge Yu.
Yeah, and I would like to just comment because I on expungements, again, it's not something the committee specifically considered with respect to expungements. I just hope that the expungement example does not undermine the consumer protection necessary when we're standing up a new licensed paraprofessional that is going to be providing legal advice. So I certainly see that there might be a sort of limited practice area that has limited risk, but for the bulk of the program and for the creation of a new licensed paraprofessional, a bond requirement is a standard way to ensure financial responsibility. And in looking at the risks and the benefits of setting the amount, we did carefully consider it. And we think the immigration consultant bond is the most parallel, although there are some differences, but we think that and if you don't mind putting up the other slide with the different bond amounts for a licensed paraprofessional, there are a number that exist. We're not writing on a blank slate, and we looked at that carefully. We did hear from various different speakers and considered the barrier to entry as well. So yeah, I do take the example of expungements being sort of the exception, but I think if we're standing up a full program, maybe you carve that out. But I think generally speaking, we want to make sure that consumer protection is a part of the regulation, and financial responsibility is an important part of that.
So we've talked before about having things be the default position potentially. So is there some way to do this resolution such that 100,000 would be the default position? And that if a subcommittee on a particular subject matter felt that it should be lower in theirs, they could make that recommendation as to their subject matter? Is that doable?
I think so. With $100,000 max, meaning my only concern is I hope that people do pursue a license in more than one area. So you wouldn't want them to have to keep adding and adding.
No.
Yeah.
Can we see the resolution again, though, the language, please? And I do see multiple hands up. I'll get to you, but I want to take a quick look at the resolution. Because right now it says an amount not less than 100. Yeah, so an amount not less than 100,000. Maybe it can be something that says, I think we do need something in there that makes it clear that kind of like regardless of the number of subject matter areas you're licensed in, or that you have something. Think about that, Leah, for a moment while we take some comments. Julia, let's hear from you.
I'll suggest the same thing. We put not less than 25,000 and not greater than 100,000.
Well, I'm not suggesting that necessarily, because I personally think the default should be 100,000. And then if there's a subject matter that wishes to make a lower recommendation, that they can do so for that subject matter, and then we can take it up as the working group. But I think the resolution needs to be clear that we're not asking. So for example, if someone goes and gets themselves certified license, whatever you want to call it, to do family, housing, and collateral criminal, that doesn't mean they need a $300,000 bond. We need to make it clear that it's 100,000, not 3.
I'm fine with that. If we're going to have the opportunity to hear recommendations of substantive committees, I can live with this.
I think it needs to be clear that that this is a strong default, that the substantive committees can certainly make a recommendation for less, not more. And that they'd have to, you'd have to really justify it in that area. Sharon?
I was just going to say that I'm in total agreement with Amos, and just a reminder that this is not per claim. And sometimes the way the malpractice works is it's not always an intentional act. Sometimes something happens in your life and you're missing an action, and you have a few people who you've messed up on the case. And if there are a few claims, that 100,000 can go very, very quickly. And if we're thinking about some of the subject matters, what is the price tag on someone losing custody of their children? So we just kind of have to think about that and stand up a program. And then also think about a restitution fund, because what happens if that bond is eaten up by a few claims?
Right. All right, Carolyn.
Unmute. Okay, so I just, again, process, and sorry to be a grump today, but I just wish, and this is no reflection on how I'm going to vote, whether yes or no or up or down. I just wish I could get these resolutions before today. I just looked at the reports.
I hear you on that. I do think, we'll talk about it offline. I'll talk about it. If there is, I will say that I agree that if there is a way, if a subcommittee has a resolution they'd like to put forward, that sharing that with the group beforehand would be helpful.
Thank you.
Okay, let's go over to the attendees in case the person with her hand up has comments related to this. Let's hear from Angela. And I'm not sure. Thank you.
So I thank you all for your work. I'd like to make a comment about overarching comments and language that I've heard here in this meeting and in other meetings. So, to the expungement scenario, that could only exist if that doesn't happen in an open market, right? Because there's alternative options. But I want to talk about the bad credit. That's not necessarily an indicator of risk, but it is representative of social inequities. It can be an access to healthcare issue, an eviction issue, which, as we know, under COVID, could be as a result of no fault of their own. So I think the point is, I think those are prejudicial statements. And I think it speaks to privilege, a privileged perspective and a narrow perspective. So I've heard other language used in here, and I appreciate those voices that speak against those microaggressions. But I've heard other comments such as, oh, someone's so, they speak so well, eloquently. That's a microaggression. I just want to ask that we be mindful of those things. And I appreciate those voices who bring to the forefront of other social inequities that I think we're facing as a society, and we should keep those in mind going forward. Thank you.
Oh, thank you. Thank you for your comments. Completely heard and understood. Thank you for the overarching comment, and then also specifically as to the credit or lack thereof issue. I think you raised some very important points for us to keep in mind. Any other panelists wish to be heard at this juncture? I see one hand. Ira.
Can we add, I'm beating this horse again, but can we add in under the first black bullet, a white bullet that says, let's see, somebody, maybe the working group can consider a lower amount of bond for the first year.
What's the rationale behind that?
Many things have been said already that.
No, I understand, but go ahead.
You mean the procedural rationale? Is that what you mean?
Well, yeah, I mean, just, trying to balance wanting people in the program with consumer protection. I just would like to hear again from you your thoughts on how that would impact consumer protection and if that's kind of okay for the first year.
Okay. I think it is okay for the first year, because I think in the first year it's unlikely to have, I'm advocating $25,000 for the first year. So I think in the first year it's unlikely that there will be a claim on a bond. It's possible, certainly. It's not even a 1% thing, but I think it's a low probability that there'll be a claim on a bond that's in the first year. But it is possible. However, all right, so what do you do about consumer protection there? I'm not sure what else can be done. Steve Fleischman advocates the client security fund. That would be good. But I think that, well, it sounds like it's likely to be $3,000 premium for somebody who has somebody of low income, because they're quite likely to have some problems in their credit history. And maybe some of the other underwriting criteria. That is a big barrier to start out for someone who of low income, low assets. Well, that's it.
Sorry, Ira. I'm just going to add, Justice Pachua, in trying to gather information on how much income these paraprofessionals are likely to earn, which I was asked to do vis-a-vis my conversations with the community colleges. I did hear from some triple LTs in Washington that, you know, they made significantly more money in the second year of their practice. So this is different point than what I don't think Ira was quite making it. But I do think there's a practical point that when you first start out, you're going to make less money than as you move along. Now, that doesn't address the consumer protection issue, but it does address the affordability for the prospective paraprofessional.
Right. Okay, before we do more substance, I need to do a typo correction on what's up here. 2 lines above where the cursor is, or 3 lines above, it says practice R subcommittees. It needs to be practice area subcommittees. And then may recommend, remove the word that. Okay, who else wants to be heard, if anyone, in regards to the, oh, Amos?
Yeah, thanks. I just wanted to, again, remind the committee, so sorry for repeating myself, but the costs and the barrier to entry was something that was considered by the committee, and the bond is the lower cost alternative. The malpractice insurance would have been more expensive, would have provided consumer protections, and is something that's familiar to a lot of professionals. But that is something that is on the table. We're not making that recommendation now, but the bond was chosen. One of the reasons was it is the lower cost alternative way to provide financial responsibility consistent with other similar licensed professionals in California.
You know, when we met with paraprofessionals from, with the paralegals from Ontario, they said actually that the cost of insurance there is significantly lower, that they pay, and this is Canadian, but they pay $300 a year for $1 million policies. And that's a lot less than what attorneys in Ontario are paying. It's more like $5,000. So it might, and I think that's because insurers have found that paralegals are a much lower risk to insure than lawyers. So, you know, that's something that we may consider down the line, that it might turn out that insurance is a lower cost for paraprofessionals.
Just to respond really, I think I'm the only hand up. Just to respond quickly to that, Linda, I'm pretty sure the Ontario program is pretty limited in its scope. So, and it'd be good to see that comparison. You don't know, is it broad?
Very broad.
It's very broad. They can provide full scope representation, including advocacy in tribunals in many practice areas.
So I don't, I'm hesitant to say that we'd modify this to 25,000 when that's not the recommendation of the, you know, working committee on this subject matter. Not on this subject matter, but on this topic. Leah, what's your suggestion on moving forward here?
I personally think we should see if we have anyone that wants to make a motion.
Yeah.
And Linda, is there another resolution on the MCLE requirements?
Yes, I made them separate resolutions because I thought there might be a lot of discussions, and I thought it would make sense to take them separately.
My hand is up. I'm willing to make the motion, and I think the changes incorporate the discussion and give some flexibility for further discussion. And I appreciate all the work that the working group or the subcommittee did. So I make the motion that we accept the resolution.
And I'll second that.
So we have a first and a second. Linda, can you take the vote?
Yes. Bashan,
Yes.
Reynoldson,
Yes.
Falmouth,
Yes.
Julie is doing. Okay. Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper, I think, is still absent. Hardston,
Yes.
I think Kim had to leave. Were you here, Kim? Okay.
Yeah.
McRae,
Yes.
Olvera,
Yes.
I think Nicole is not here, nor Judge Rubin. Shining,
Yes.
Oh,
Still
we have,
absent.
I'm sorry, we have Judge Harper in the attendees. Could you please
Oh.
move over?
Okay, yes, I will do that. I didn't realize that he was there. Let me do that now. Okay. So Judge Harper, I don't know if you heard enough of the discussion, and I apologize.
I did.
See you
I
there.
did. I vote yes on the motion.
Thank you.
Thank you.
And I think Fariba is absent. Spyro?
Abstain.
Okay. I think Claudia is still absent. And Judge Wiley, I don't believe has joined us.
She has.
I have.
Oh, I'm sorry.
That's
I
all right.
apologize. I didn't see you here.
Not a problem. Having reviewed the resolution, I vote to approve.
Judge Yu,
Yes, thank you.
the motion carries.
All right. Thanks very much. I
Can
think,
we do the MCLE
yes,
resolution?
let's move to the
Yes.
MCLE.
Let me bring that up now. Okay. Okay. And this one, I'll have to, I guess I can. I don't know if it's better to have it smaller like this.
It's
so that you
okay.
can see the whole thing at once.
Yeah, that's fine.
Have a motion?
Well, give people a moment to read it. And by people, I mean myself, because I'm still reading. So this is, to my quick review, largely what we have discussed before. Could someone from the subcommittee tell me if there are any significant differences that should be brought to everyone's attention?
It is what we discussed before. The 2 points that I called out, changes from our prior recommendation, is the last 2 bullet points under the 36 hours, 1 hour of trauma-informed practice and 1 hour of practice management running a business. Those were additions of requirements to try to address specific issues and concerns and sort of do best practices. but otherwise I believe it's consistent.
All right, thank you, Amos. Does anyone wish to be heard on this or have any questions about this? I see, let's start with Stephen Hamilton, please.
I do. I think that the first bullet point under the 36 hours where it says 28 hours in the paraprofessionals practice area singular, we should change that to plural so that, because otherwise they'd have to do 56 hours theoretically if they got 2 certifications.
Thank you. Judge Yu?
Our pilot subcommittee wrote a letter to the regulation and licensing committee to ask that they look through a lens of sort of helping people launch into the program. And I was wondering if changes were made to reflect that request.
So let me remember, because we did have a meeting specifically on MCLE or included in our meeting after the letter, which was well received. I'm trying to remember if there was a specific recommendation. I think part of the discussion after receiving that letter was actually that we might need to increase the number of hours from 36 to 42 because we learned details of what California attorney specialists, their licensure require or their MCLE requirements, although it says 36 hours in the regulation, it actually can be up to 42 hours because it's not always counting towards a general. So I think what we ended up doing was not increasing to 42 hours, but I don't remember if there were, and I think part of that letter was also the trauma-informed practice and including that. So we did decide to include that. And I think that came as part of your recommendations as well. That is my recollection.
Thank you. I'm not sure the trauma-informed piece was in the letter, but I do remember discussing it and I'm so glad that it's there. Thank you.
Carolyn?
Okay, so someone brought up a great point that I hadn't thought about, and I think it was Stephen Hamilton and a couple other people. In our subject matter civil procedure, general civil subcommittee, we're talking about court representation in wage and hour and employment. And I think it's no secret that I'm opposed to that. And it's no secret that we've had literally over a dozen specific public comments from both plaintiffs bar and defense bar individuals who say that that area is a phenomenally difficult area of law. It's a specialty by lawyers with years of experience. So if you double up in family and wage and hour, I don't know that 28 hours is enough. An attorney with 23 has a choice of doing those things, but if you're in employment, you don't do family law. So if this is easier to get into 2 certifications and you don't have that time, someone just wrote a letter, and I don't know if it's a public comment, that there were 3 opinions that came out last week. One is a federal opinion, one was a state opinion, changing the law, drastic changes to the law of wage and hour. So, so I'm not sure. I think with some of these subcommittees, if we get into and allow, and I'm greatly opposed to it, the wage and hour segment in the general civil, and there's some questions about some of the consumer issues. I don't know that 28 hours for someone who hasn't gone to law school and has a broad understanding of the law and their specialty really hits the mark. I think, you know, what Steve said, maybe 50 hours is required, but if you're going to do 2 massive areas that lawyers absolutely specialize in, and I see Ira's hand going up, and I know what he's going to say, maybe. So,
let's see if you're psychic, Ira.
I wanted to say that right now, as far as my view and on wage and hour, I'm advocating only that that paraprofessionals be permitted to handle those cases only if up to $25,000. And I don't think there's anybody on that subcommittee who is advocating any higher.
Okay, Julie?
Julia, sorry. This is MCLE. I think we've already talked about in licensing the underlying education. So this would be different, Carolyn. the model we have for licensing is what controls the education they're going to have to receive if they don't waive out of those core courses. So this is, as I understand it, just the recommendations for continuing education. This is not the
That's correct.
education model.
Okay, anyone else? I don't see any hands. Okay, is anyone ready to move?
I will move.
All right, Amos, do we have a second?
Second, Dana.
Thank
And
you.
I'm going to make a friendly, or maybe not a friendly amendment. Can I make a motion to amend?
Not a motion to amend. You can ask the person who's sponsoring the motion whether they're willing to accept a friendly amendment.
Okay, I'm going to try. I would make ask for a friendly amendment that the 28 hours in the paraprofessionals practice areas, if the subject matter committee on general civil and consumer areas allows those two to go forward, and then that has to be a special additional practice area amount, maybe not up to 28 hours, but has to be, those two areas I think need to be specified and broken out.
Amos?
Yeah, I'll just say that I think we tried to cover that topic under the third arrow, that each practice area subcommittee may require that the above include specific topics. So it doesn't increase the amount, but there could be specific topics or areas that may be particularly complicated or raise particular concerns that the practice areas. So I think rather than amending this motion, that it could be handled under that.
Okay, so I'm not hearing an amendment. Anyone else before we take a vote? No, then Linda, go ahead.
Okay. Bashan,
Yes.
Reynoldson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston.
Yes.
I think Kim is absent. McRae,
Yes.
Olvera,
Yes.
Nicole is still absent. And Judge Rubin is absent. Shining,
I'll say no.
and Fariba is absent. Spyro,
Yes.
Claudia is absent. Judge Wiley,
Yes.
Judge Yu,
Yes, thank you.
motion carries.
I like how Judge Yu always says thank you for the opportunity to vote. So, okay. Setting a good example as usual. Leah, Linda, do we have more on our agenda for today?
Well, Amos, I think you had intended to engage the group in sort of a policy discussion. We were going to give an update on proactive regulation. I'm wondering where
Let's hear from Amos. Where are we?
Yeah, so as I mentioned, there are a lot of other topics under review by the Regulations Subcommittee, some of which I think are controversial, some of which we could use the input from the public and from the entire working group, particularly fee regulation, proactive regulation. What I would do is defer to the chair a bit, but let me just give this brief overview of sort of the possible discussions. I don't know if we have a slide for the table 1 in our report, but the issues that we have identified that we are currently considering include, as Leah mentioned, the proactive risk-based regulation. We had a full working group discussion about that. That is something that we included in our report. We don't have final recommendations, but we are discussing, and I think the bar has identified that as something we really want to look to include. Fee limitations are controversial. We haven't reached an agreement on that. We are looking at allowing paraprofessionals to set up their own practice or potentially work with attorneys, and that implicates fee sharing and referral fees, which is also tricky. We're not ready with recommendations, but that's another area. We have some draft language that we put in for some other areas like informed consent, written agreements and disclosures. So, you know, I'm happy to engage on
Well,
any
that's a lot. I mean, those are a lot of topics. You know, clearly we're not getting through all those topics in the next 40 minutes. I mean, I'd leave it to you in that if there is something where you feel, I mean, it's always helpful to have a proposal. I understand that your subcommittee doesn't have finalized proposals for these, but if there is something where there's a tentative proposal or something for us to look at and discuss, I think that can be helpful as opposed to kind of a conversation in a vacuum.
Yeah, Leah, do you think that would be proactive regulation? Do you want to discuss that?
I was actually thinking that's probably not the one. I think maybe, Amos, it would be valuable to get a temperature check from this group on fee caps, to be honest with you. It's not a proposal, Justice Patru, but it is the most controversial thing being considered. And I think it would be helpful.
Yeah, we don't, so I'm open to that. So we do not have a recommendation and we do not have agreement at the regulation subcommittee, but it is something that we are grappling with. And as
are you able to not to put you on the spot as I put you on the spot, so consider yourself on the spot, are you able to give us the, you know, kind of the strongest arguments for and against that you've been hearing in regards to fee caps?
Yes, happy to. And by the way, this might be another area where it's practice area specific, because we've heard particularly in family law that that's challenging. And there's a lot of different things going on in family law, but in housing and in consumer debt, we've heard quite the opposite, which is it's often a flat fee and fees are often very low for attorneys. And so the concern is that we'd be creating a program that doesn't actually provide a lower cost alternative if paraprofessionals might be charging rates that are higher. So this might be practice area specific, but generally speaking, I think we've heard even in public comments today that generally the argument against any kind of fee restrictions or fee caps is let the market decide, and that will work itself out, and there's no similar regulation for attorneys. So the idea is let's not regulate this, and it may work itself out that paraprofessionals will charge lower rates than attorneys, and that there's not necessarily an issue that we need to address for paraprofessionals. Now, let me say, I invite anyone who wants to give a stronger argument, because I do not agree with that at all. But that is what we've heard. It's not regulated for attorneys, so why would we regulate it for paraprofessionals? And why do we assume that paraprofessionals would overcharge? I will add that we have heard when we were doing the proactive regulation discussion and when we were looking at what are the primary risks we are concerned about that we need to regulate, overcharging and excessive fees always comes up as a primary risk and concern. And of course, it's fundamental to why we're doing this, that we're trying to make a lower cost alternative available. So I think we shouldn't necessarily just abandon this discussion because it's difficult, but I think we have to do the heavy lifting and figure out. And I think at least in some practice areas like housing and debt collection, it may not be that complicated to do. But let me give the other argument, which I've sort of hinted at, which is, the point, one of the main points, not the only point, but one of the main points of this paraprofessional program proposal is to provide access to justice, a lower cost alternative to hiring an attorney. And maybe in some areas, geographically, there may not be other alternatives. So creating a better alternative than what is currently out there. And fee restrictions or limitations in some form. Fee caps are only one possibility, but some kind of regulation of fees, whether that's disciplinary or a bright line cap or some other alternative. I think we could be potentially open to some kind of regulation, but my position is that setting this up as a licensed paraprofessional, the whole point of this is so we can provide some consumer protections and regulation. And if affordability is something we truly care about, to not have disciplinary restrictions on reasonableness of fees, or to not have some sort of fee limitations or caps, I think we're going in the wrong direction. So that is my feeling. And again, we're still hearing from, there's very strong and very different opinions in this area.
Well, and these are two different, not totally different because they're related, but the issue of a fee cap versus potential discipline for, you know, charging outrageously, for lack of a better legal term, excessive fees, I guess sounds better. Those are two different issues. I doubt that we're going to get any, I mean, someone pipe up. Is there anyone who doesn't think that there should be the ability to discipline for charging excessive fees and appropriate fees? Anyone?
So can I just address that? Because that is, I think you're exactly right, that discipline for excessive fees and mandatory fee arbitration, by the way, which is something the discipline committee is all related to whether or not, you know, how we regulate. And I think that's a possibility. I think for attorneys, there is no reasonableness fee requirement. And I think that is intentional. There is a, Greg could help me out here, but there are some limitations, but it's not, you know, it's not compared to what other people are charging or reasonableness. That is not currently part of the discipline. So that is something we would need to create, which I do think is one way.
Now we actually have three subject matters. So then, and thank you for reminding me, there's the mandatory fee arbitration. I thought, and I can be, please someone correct me if I'm wrong, I thought there was generally group consensus around the idea that there would be a mandatory fee arbitration process similar to the one that exists for attorneys. Is that correct?
Yes, we just approved that.
That's what I thought. I'm like, I thought we already said yes to that. So let's, I think that, thank you, Amos, for reminding me of it, because I do think it's important that we know what already exists or what is almost certain to exist. So mandatory fee arbitration, that's happening. Okay, so we know that piece as part of this conversation. There's the issue of, should there be a potential discipline? That I think is something that's going to have to be discussed. And there is the fundamental question, which is where I think we really should start, which is, should there be fee caps? And are we able to, in some things, like we saw earlier today, in some areas we can say there is a default. Here is our default rule. Now, is that going to be something that we can do for this? Or is there such a strong feeling that in subject matter areas where it tends to be flat fee, there should be some kind of cap, as opposed to family where we know things can get out of control with the amount of time that has to be dedicated to it. So Amos, are there other comments you'd like to make before we open the floor?
No, I think that's a great discussion. I'll just say, for discipline, if we are going to have discipline for unreasonable fees, we have to create a standard for what's a reasonable fee. And that's the difficult part.
We have a number of hands up. I don't know if you want to ask Greg to jump in. Greg, were you going to speak to that specific issue?
I was actually.
Go ahead.
Just to give some context for the group, in terms of what the rules that apply to lawyers. So California is a bit different. There are other states that follow this standard as well, including Texas. But the ABA model rule 1.5 prohibits a lawyer from charging an unreasonable or illegal fee. California does not follow that standard and hasn't for many years. We establish a disciplinary standard for lawyers that they cannot charge an unconscionable or illegal fee. And we have a number of factors under our counterpart rule 1.5 to consider. And here's the rationale. And this is probably one of the arguments also that would factor into the consideration of fee caps. We have limited resources in our disciplinary system. And so the court has made a decision, a policy decision, that they will reserve the sanction of attorney discipline for the charging of an unconscionable fee. And usually what that includes is some element of fraudulent conduct by the attorney, some level of overreaching. And that's reflected in those factors under Rule 1.5. In terms of a attorney charging unreasonable fees, we have found that the mandatory fee arbitration program works fairly well in that regard. When there is a dispute between a client and an attorney, for instance, if they've spent too many hours preparing a motion and it doesn't really follow the standard, usually that's sorted out through mandatory fee arbitration. So to the extent that we are going to impose a standard on paraprofessionals, a disciplinary standard for charging an unreasonable fee, that will diverge from the standard we're imposing on attorneys. And I just want the group to understand that, and also understand the policy decision we're making about what do we reserve for discipline and what do we reserve for other forms of regulation. And that's the only point I wanted to make.
Do you want me to call on folks? We've got Steve has had his hand up for a while.
Thank you. Yeah, I'm strongly in favor of imposing fee caps. I agree with Amos. It doesn't have to be across the board by all subject matters, but this group is supposed to be concerned with consumer protection. And the average consumer is not used to reviewing bills from an attorney, itemizing tasks performed and reviewing those and paying them on an hourly basis. In fact, you know, this is anecdotal, but I just had a call from a good friend last week complaining about her bill from her family law attorney. Why do they bill 0.25 for every phone call I make? Those are the types of problems that come up routinely when you're billing on an hourly basis. I think many of the subject matter areas we're including, like name changes, like gender changes, like collateral criminal, clearly lend themselves to flat fees, whether it's $750 or $1,000. You know, there's a joke in the pharmaceutical industry, the first pill costs $1 billion, but everyone after that costs 3 cents. If we're doing our licensing right, someone can figure out how to do a name change while they're working for an attorney. And when they get into private practice, it really shouldn't take more than an hour, maybe 2 hours, and a reasonable flat fee, you know, can be determined. I also agree with Amos. We heard about debt collection. It can be done there by attorneys who make a living doing it, and it should be done in housing also. I recognize family law may be a different animal, and maybe we carved that out, but there are, for policy reasons, limitations on what attorneys can charge. MICRA is one of them. Workers' compensation is another one. And I think we should be, I'm in favor of fee caps for all those areas except potentially family. And on family, I'd want to hear from Steve Hamilton. Thank you.
Okay, I think it's Julia.
Yes, I was going to raise the same point that Steve just made. I mean, we do have some caps. We have workers' compensation is the one that came to mind for me also. But I also think that there are certain settlements that have to be approved. For example, if you got a minor involved in things like that. So it's not purely unregulated and uncapped. So there are instances of seeing that in our practice. But I don't know if it's appropriate now, but I do hope that when you're discussing the fee sharing topic, that you do consider that we really want to design a program where these folks are not working as cappers for attorneys. And however you can make that look and achieve that, I think it's very important. I can see some ways that if the attorney can now share his fee with a paraprofessional, they may become a marketing instrument, I guess, is in not a favorable way. So that's my only concern about that.
Carolyn, and then Stephen, and then Greg.
Okay, all right. So here we go. This is a massive issue, and I agree with some of what everybody said and not some of what everybody said. I really think this needs to be put off to the almost very end in some senses until we know the subject areas. I don't think we can possibly vote on this particular
No,
matter.
just to be clear, Carolyn, we're not voting. We're just having a discussion.
Oh, I know. At any point. No. My point is, I don't think we can vote on this area until we absolutely know what the subject areas are. They're so vastly different. The economics are so vastly different. But let me point out something else to you. There's another parallel group. I think you all know the Sandbox Committee is going on and getting started and is going to be in parallel with us. And in Utah,
Well, hold on 1 second on the sand. This is Justice Petra speaking, because I'm in contact with the chair of that committee. And in fact, Lee and I spoke to that committee and gave a presentation as to where we are. We will continue to be in contact with them. They are way behind us in the sense that they will be about, just so you know, their recommendations will come about a full year after ours do.
Well, in Utah, Your Honor, and everyone, there's absolutely a non-lawyer company that has been released from the sandbox. It's called Law on Call. It's going to offer a wide variety of services. They're licensed lawyers that are going to be working for non-lawyers. But when I was listening to the ATILS group and walked through in ATILS 1, there are massive, and this Julie elaborated on this, there are massive changes that need to be made to the rules of professional conduct in this area. And it really stymied them. And I know we're going to hear from Professor Moore, and maybe we can talk to him about this particular issue. But Julie brought up the issue of capping. There's antitrust issues. There's IOLTA issues with flat fees, where people have to keep their flat fees in a trust account and then not take them out of the trust account until the services are rendered. This is something that we want to see, and I think we want to understand where the Sandbox Committee is going.
Yeah,
Because this
let
is.
me just jump in with the Sandbox Committee. I think it's important to have a sense for what they're thinking about, but I can guarantee you that, not guarantee you, but we're not going to have a definitive answer from them as far as where they are going in advance of our having to make decisions. So I think it's important to keep open the lines of communication. I am glad to, if it seems appropriate. It's not appropriate right now because they're really in their infancy, but I'm glad to, if it feels appropriate in the upcoming months, to invite the chair of that working group to come give us an update, as I just did for them in the last few weeks. So I think it's important to understand where they're heading. It's important to understand that there likely, may be some kind of I don't even know if I understand the term sandbox, but some kind of set of self-help, essentially online automated tools that may actually reduce the need for some of the paraprofessional work that we're talking about. So absolutely, I agree that's all important. I just want to make it quite clear to everyone that we are not going to have final answers. And so while we should be making informed decisions, they will not be fully coordinated decisions.
Yeah, I just wanted to raise that, and just, this is an issue that I'm going to really study and listen to what comes out of regulation, because again, the subject matter areas that I'm really having trouble with are just going to be massively impacted by this. I just don't think we're going to be able to narrow anything on this until we know what's in there. And just being able to say, oh, we'll put it off and those groups can fix it later. I just don't think that's appropriate. It blends into and informs that discussion so severely, especially with wage hour carve-outs for non-PAGA court appearances at all levels. I don't know how you deal with that in a generic discussion of fee caps. I just don't know how that's even possible. So those are my comments right now.
Greg, could we hear from you, please?
Yes, I'm also a liaison to that group, Carolyn. So I will be, and I attend every one of their meetings. As you can tell, I'm attending a lot of meetings every day. So I will be attuned to where they are going. Justice Petrou is correct. We are just getting out of the gate. There is some overlap, especially when we get to Rule 5.4 and any changes we want to make to 5.4 with regards to a subject that Amos brought up that we're not going to discuss today, which is the extent to which paraprofessionals can combine with lawyers in the same firm. There is a bit of a difference, though, because we're envisioning this to be a licensed professional. These are two licensed professionals combining potentially in a firm, as opposed to a company that for which lawyers may work and that may be in the business of providing legal services to the public. So there is a slight difference in terms of what we're talking about, but both groups potentially could touch Rule 5.4. The other point I wanted to make based on Steve Fleshman's comment, I just wanted to underscore as well, Rule 1.5, I did say it prohibits lawyers from charging an unconscionable or illegal fee. And so where we see a lot of 1.4 violations are lawyers who charge illegal fees under MICRA, who violate our loan modification laws in terms of what they can charge, and in workers' comp. So that you may be subject to discipline to the extent that you violate those statutory provisions that limit the fee that you can charge.
Steve Hamilton?
Okay, when I brought up this issue of some form of fee caps, whether it's a cap on the hourly rate or flat fee charges with the California Lawyers Association, when I gave them an update about what we're doing, the antitrust and unfair competition section weighed in and said they'd have grave concerns about the legality of most of, for sure trying to put a cap on the hourly rate that's charged. I don't think they took a position with regards to the flat fee. I will tell you within the family law field, absolutely flat fees are discouraged because what it incentivizes a lawyer to do, and this would be the same for a paraprofessional, is to do the least amount of work possible. It really puts a conflict of interest out in front of the family law attorney. That's one of the reasons, similarly, I don't do family law real property liens, which are commonly done, because it puts you in competition with your client over the equity in a community residence. So I know that there are flat fee agreements out there. Most of them have a certain amount of work until then they kick in, but flat fees are absolutely discouraged for ethical and practice reasons within family law. I think that the reasonable fee issue is going to be addressed in two different ways and should not be part of our specific recommendations. I think that if there is an exorbitant fee charge to a client of a paraprofessional, they're going to be filing a complaint to the board. And it's very common in family law that you're working to get paid later, not being paid up front. It could be either part of a fee arbitration proceeding where the reasonableness of the fees will absolutely be considered, as they are in fee arbitration for family law attorneys, or it'll be a disciplinary issue because someone charged for something that they shouldn't have done, or they charged them an excessive amount. So I'm taking the position that I don't think we should be regulating the fees charged by the paraprofessionals. And Steve Fleischman, to answer your question, your friend got charged 0.25 or 15 minutes because she signed a retainer agreement that says it.
I know that.
Mine says 0.1.
Yeah.
And I don't usually charge. I've actually do a lot of no charges, but that's something where they can change it. It's within the consumer's power to change it. And in family law, a couple of different things. Number one, you have to give detailed billing statements. That should be a requirement on the paraprofessionals as well when they're charging. And number two, even I violate this, you're not supposed to do one bulk entry. You're supposed to do each individual event or thing. Even if you do 5 things in a day, there should be 5 separate entries identifying the time that you're done. There's a case on that. Remember, there was the recent case where it was a personal injury case and the attorney asserted a lien and he created this bill with the times that he charged. And the court was very keen to point out it's odd that everything's billed in half-hour increments, and it came out so perfectly.
Happens all the time, Steve.
Yeah,
No block billing. It's the vein. It's the vein.
You're all making me glad I'm a judge and I don't have billable hours anymore.
Oh, I'm running the clock all day long, and I do the timer so that it's all recorded. So I would say that the concerns that are being expressed about the consumers being taken advantage of, there's going to be remedies. It's either going to be fee arbitration or it's going to be a disciplinary complaint filed. I think we run afoul of potential lawsuits challenging any fee limitations we impose. And I think it would actually, a fee limitation would encourage bad practices by paraprofessionals, as I know it encourages bad practice among family law attorneys. Thank you.
Stephen Fleischman, did you have some comments?
Yeah, Justice Petro, with this other group, the other group's been given specific charge to look at the issue of attorneys sharing fees with non-attorneys. I don't see why our group should be getting into that at all. we should just defer to them, let them come up with it. Otherwise, you have the potential for conflicting proposals, or our proposals going to weigh in on them. I think we should just stay out of it, just as, golden rule argument. I frankly would kind of expect their group not to come up with proposals that conflict with our proposals. So, I mean, it's a two-way street. They've been given specific jurisdiction to look at the rule of professional responsibility that prohibits a lawyer from sharing fees with a non-lawyer. Okay, our paraprofessionals are going to fall in that group, and that can only be changed through that rule, which that other committee's been charged with. I mean, I hate the phrase sandbox, but let's play well with each other on the playground. I don't want to be stepping on their toes. I don't think they should be stepping on our toes. And I think the referral fee is the easiest, most obvious example where there's conflict, because they've been given specific charge to deal with that.
I appreciate your raising that, and I'm going to, shine a spotlight on Greg and ask him to please keep us apprised as we're having these conversations if things come up where, because he's certainly going to be more conversant than I am off the top of my head with exactly what is their charge.
And if I could also just briefly address that, because I generally agree, if we could defer issues to the other working group, I would love that. But I think where the referral fees and fee sharing, where we just as a practical matter have to deal with it in one way or another, is if paraprofessionals are allowed to practice with attorneys in the same firm. And what are the restrictions if a paraprofessional refers? Is that are we going to treat a paraprofessional as a non-attorney, or a paraprofessional as a licensed paraprofessional in the legal practice? I think we just have to make a policy decision, practically speaking, on those issues, even if we want to defer mostly to the other working group.
I mean, I would just say they're governed by the rules for paralegals until the other committee says otherwise.
Elizabeth?
Thank you. I was going to speak on the fee caps, but I did want to address the point that Stephen Flashman just brought up, like, why are we talking about this in this group? And the reason that I believe is because attorneys are going to hire these paraprofessionals. I think it's a reality. These paraprofessionals, they're good at the process, the procedures, and they have the right contact with the clients and the knowledge. And so we heard from, I believe, the LLT in Washington, Ms. DeVay, that a lot of these LLTs are working in attorneys' offices. So they're already being connected. So that's why we're having the conversation, because it's going to be a reality, I believe. A lot of current legal document assistants are working, directly with attorneys to refer the client directly to the client. They give them a list of, these are 3 attorneys you can reach out to, and then they let go of the process. So there's definitely going to be some kind of overlap there. But anyways, I'm going to the whole fee cap. The goal of this program is to increase access to justice and to give the consumer the choice of who they want to hire to help them. I believe that the market will regulate itself, like we've been saying. If you tell the member of the public that it's going to cost, let's say $1,500 for a divorce, and they feel that that's attorney pricing, then they might go to the attorney, right? And they're not going to use the paraprofessionals. And they also have other options available to them. And so that's my thought on that. And then also we have to remind ourselves that these paraprofessionals are going to be business owners, and they have operational expenses. So if it's not clear, I don't agree with the fee caps. But these business owners are going to have operational expenses, postage, marketing. They have places where these people can come to. I know that I work with a lot of the Latin community, and they don't have email address, access to a computer They cannot, even if I have online questionnaires, online contracts, or virtual Zoom, that's not what they're going to, my client demographic is going to be able to do. So I can run my business more efficiently and cheaper, but at the end of the day, I still have to have a brick and mortar location. And it just really depends on the services that these paraprofessionals are going to offer. Again, I'm against the fee caps.
Thank you.
If I could just interject, I'm sorry, but I just want to say, Elizabeth just more eloquently put one of the main arguments, I think, against fee caps, which is, this needs to be a business opportunity for professionals. And so they're going to need to set their charges based on how they can run their business. And one of the public speakers, I think, also commented on, the pressures of fee caps could lead to the need to take on a much higher volume of cases. And I think both of those arguments are fair arguments and counsel against fee caps. And I don't know where that leaves us with the disciplinary options or how we regulate reasonable fees. But Elizabeth, I think those comments are very well taken.
Yeah, I agree. And Amos, not to throw you under the bus, but I agree that it was very well put by Elizabeth. Ira.
I'm not sure how I stand on fee caps, but I really question whether discipline and fee arbitration are effective in deterring excessive fees. For instance, somebody pays an exorbitant fee for some kind of service. They pay it, the money's gone, the service is done, and then what would make them think to make a discipline complaint or do a fee arbitration after they've agreed to this fee and paid it? I mean, I don't see that happening. If the result is bad, yeah. But if the result's okay, I can't see it happening. And yet they would have paid way too much. Thanks.
Greg, I think you had your hand up.
Yes, I just wanted to discuss, so everyone understands the difference between fee sharing among non-lawyers. Fee sharing among lawyers from different firms, which is really governed by Rule 1.5.1. And that, to the extent you comply with that, that allows for pure referral fees among lawyers. We're a bit different than most states in that we allow those pure referral fees. I don't want to confuse that with 5.4, which really restricts lawyers from sharing directly or indirectly fees for legal services with non-lawyers or with an organization authorized to practice law. I don't see, with all due respect, Steve Fleshman, I don't see how we avoid having some discussion about Rule 5.4 here, to the extent that a lawyer wants to hire a paraprofessional. If you don't touch 5.4, they are going to have to pay that paraprofessional a salary. So who is the fee cap operating on? The firm, the attorney's firm, in terms of what they can charge. And I think you have to make a policy decision. And I wouldn't worry about the court getting confused about competing proposals from these two groups. We're monitoring what they're doing. And as I said, there is some overlap, but I don't see how you can really fully stand up this program without wrestling with 5.4 and what the allowable relationship between lawyers and paraprofessionals is going to be and how it's reflected in the rules.
Stephen Fleischman.
Yeah, all right. So let me respond to Greg. Greg, I think it's real simple. If the paraprofessional is working with an attorney under the supervision of the attorney, then the rules governing paralegals apply and the attorney can pay the paralegal. And I don't think the fee caps would come into play because it's the attorney providing the legal service and the paraprofessional would be doing that work through the attorney. All right. We're talking about fee caps where the paraprofessional's out working on their own. The reason I raised my hand is Steve Hamilton's convinced me there shouldn't be fee caps for family law, but I'm curious about his views on fee caps for, say, name change, gender change, collateral criminal, things like that, that seem to be fairly, form driven and don't raise the conflicts that you described for family.
So let's hold for one moment because I do have a couple of hands up. If we have time, then we'll turn it back so that Steve Hamilton can respond to your questions. But I have Julia.
Yeah, I just wanted to say, I mean, just so we're clear, paralegals cannot set their own fees. It is against the Business and Professions Code for them to set a fee. So they have to work under attorneys. So I just want to make sure we're not confusing things. There is no such thing. It's in 6450 through 6456 of the Business and Professions Code. They cannot set their fee. The lawyer sets the fee and then the lawyer pays them. So if we're envisioning that there's going to be one set of rules for the paraprofessional who associates in a law firm and they're going to be paid a salary, I think we need to consider if that's the design here, that's going to be a different payment structure than the paraprofessional who sets up their own shop. Then they're going to be setting the fee. They're going to be more like a lawyer practicing law than a paralegal would be. So those are two different, quite different environments.
And then Carolyn, please.
Okay, so just first of all, I couldn't agree with Julia more. I would add one thing though. We need to consider paraprofessionals working for large mega companies. And so I think that's the thing we ought to grapple with. Is this going to impact what a Walmart and Amazon.com, a law case, kind of thing.com are doing? So that's a third category I think we really need to talk about. Consumer protection issues with regard to walmartlaw.com. The second issue is the 5.4 issue was something that the ATILS 1 committee had meetings on. And they came up with the only recommendation they could agree on was that fees were shared with non-profit entities. They changed 5.4E. There's several different memos on it. I participated in public comment on that very, very strenuously. There were hundreds of letters of public response on that issue alone. So it's not a small issue. I think it has to be discussed at the end of our discussions, and it has to be just, this is just not a thing this is a thing that's been very vetted and being very vetted around the country.
I'm so sorry to interrupt, Carolyn. I need to hop off, as Leah is aware. I have a medical appointment that I need to get to. I am going to ask, though, whenever Carolyn is done, that Greg be given the last couple of minutes here to wrap up, and that this meeting end at 1 p.m., please, because I do try to have it that we don't go over.
No,
sorry,
I'm done, Your Honor. Submitted.
Great, Greg.
Yes, the one thing, Carolyn, the ATILS group, which I was also liaison to, it seems to be my thing. The reason they only proposed those amendments to 5.4 was that's the only thing that could get consensus on without further study. The ATILS committee also recommended the creation of this group, as well as the closing the justice gap group, which is dealing with the sandbox. So we're both creatures of the ATILS group. And it was contemplated that both groups are going to have to wrestle with different parts of 5.4. So I don't think we get around that. My concern, Steve Fleshman, with what you propose, and I think Julia, you alluded to it, to the extent we have statutory fee caps on paraprofessionals only if they're practicing outside of the supervision of a lawyer, I'm concerned about the antitrust considerations there, because as long as a paraprofessional works for a lawyer, they can charge whatever they want for paraprofessional services, but those same services are subject to a cap. That I think you're going to have some pretty strong arguments and challenges to that type of system. So, and I'm not sure that's the optimal type of system that we want to see here. I think there's a lot of strong arguments in terms of pure referral fees on both sides, and I think this group's going to have to just hash that out. But again, I don't think this group will have done its job unless they really try to think through the permissible relationship between paraprofessionals and lawyers and how that needs to be reflected in the rules. And it may require a change to the lawyer rule as well in order to make that happen.
So Stephen, we have 2 minutes left. Steve Fleischman posed a question to you about any other areas where fee caps might be appropriate in your view. Do you want to answer that now or take that up later? I think we will have time. We'll be coming back to fee caps. I believe we'll touch upon that at our April meeting on the rules. I think it looks like we aren't going to hear from Stephen today, and it's 12:58. I think we can close this meeting out.
Yeah, let
Thanks,
me just say, very helpful discussion. Obviously, no clear answers. Very controversial arguments on both sides. And there's a couple issues that we're dealing with in regulation. So we will take this back. Fariba and I have different views on some of these issues. So we're getting some of these discussions at the subcommittee level. But we're gonna discuss it. If anyone wants to participate in those discussions, you're welcome. And hopefully we'll come back with some proposals.
Thanks, everyone.
Thank you. Bye.
Okay, bye.
Thanks, everyone. Bye.